The Caribbean IP Annual 2025. Front cover text. The Caribbean IP Annual 2025. Profiles. Regional reports. Thought leaders. Promoting IP excellence in the Caribbean. Profiles, articles, experience, achievements, accolades, plus much more inside. www.caribbeanipannual.com.
Page 2. Inside front cover advertisement. FOGA Daily, Attorneys at Law. Patent and Trademark Agents. Celebrating 25 years of mastering law's new frontier. Trusted for our dedication, driven by our passion for intellectual property, and thankful for our team and clients who continue to make it possible. FOGA Daily founders, Nicole Foga, Rachel Lodge Corey and Diane Daly McClure. Email, info@fogadaily.com. Website, www.fogadaily.com. Address, 7 Stanton Terrace, Kingston 6, Jamaica. Tel, 876-927-4371-5. Fax 876-927-5081.
Page 3. A word from our CEO. Carlos Northon, founder and CEO at Northon's Media PR and Marketing Limited, London, UK. We are delighted to present the inaugural edition of the Caribbean IP Annual 2025, a landmark publication and the first of its kind, dedicated exclusively to highlighting intellectual property, IP, excellence across the Caribbean. This edition marks a significant step forward in bridging the information gap between Caribbean countries and the wider global IP community. As we launch this platform, it's important to recognize the foundational role the World Intellectual Property Organization, WIPO, has played in supporting the development of IP frameworks throughout the region. WIPO has long been committed to empowering Caribbean nations through technical assistance, legislative reform, and the promotion of IP education and awareness. From supporting the digital transformation of national IP offices to building capacity through regional training programs, WIPO's involvement has been vital in helping the region navigate the evolving global IP landscape. In collaboration with regional institutions and governments, WIPO has also worked to harmonize national legislation with international treaties, such as the Madrid Protocol, the Patent Cooperation Treaty, PCT, and the Berne Convention. Their focus on empowering innovation ecosystems, especially within creative industries, traditional knowledge, and small business sectors, resonates strongly with the vision of the Caribbean IP Annual. Initiatives such as the establishment of Technology and Innovation Support Centers, TISCs, as well as the WIPO Caribbean office in Trinidad and Tobago, demonstrate a clear commitment to regional integration and IP-driven growth. Against this backdrop, the Caribbean IP Annual aims to complement WIPO's efforts by offering a dedicated platform to spotlight the voices of legal experts, policymakers, and professionals shaping the region's IP narrative. We have assembled a compelling magazine that features leading experts from a variety of Caribbean jurisdictions, each generously sharing insights and perspectives that provide a deeper understanding of the IP environment in their respective countries. Over the last few years, through our flagship publications, the Global IP Matrix and the Women's IP World Annual, we've had the pleasure of working with many IP professionals across the Caribbean. Their stories have inspired us and informed our global readership. Building on those trusted relationships and the wealth of expertise we've encountered, we felt the time was right to create a publication solely focused on the Caribbean. This new platform allows us to shine a spotlight on the unique challenges and opportunities within the region, while also connecting Caribbean IP professionals with a wider international audience. From regional case law developments and legislative updates to interviews and expert commentary, this publication is designed to serve as both an educational resource and a celebration of Caribbean innovation. Whether you're a practitioner in the region, an in-house counsel looking to better understand local systems, or a policymaker seeking regional perspectives, we hope you find the Caribbean IP Annual 2025 to be both informative and inspiring. Thank you for joining us on this journey as we continue to bridge islands, jurisdictions, and communities through the shared language of IP. Published by Northon's Media PR and Marketing Limited. Carlos Northon. CEO and founder, Northon's Media PR and Marketing Limited, publisher of the Global IP Matrix, the Women's IP World and the Caribbean IP Annual. Carlos at northonsprmarketing.com. Dhruva Dakani, Director of Creative Design and Global Marketing for the Global IP Matrix, the Women's IP World and the Caribbean IP Annual. Dhruva at northonsprmarketing.com. Igor Lang, Global Sales Account Manager for the Global IP Matrix, the Women's IP World and the Caribbean IP Annual. Igor at northonsprmarketing.com. Craig Barber, Head of Design for the Global IP Matrix, the Women's IP World and the Caribbean IP Annual. Info at northonsprmarketing.com. Page 4. Contents. Page 06. IPCA Opening Letter. Hugh St. J. Moses, OBE, Director, IPCA. Puerto Rico. Page 07. Ferai Woli, Managing Partner and Co-Chair Profile and Article. Striking a Balance, IP and Data Protection in Puerto Rico's Digital Economy. Eugenio J. Torres Oyola, Managing Partner and Co-Chair, Intellectual Property at Ferai Woli, Puerto Rico. Jamaica. Page 11. Foga Daily, Senior Partner Article. 3 Decades of Intellectual Property Transformation in the Caribbean, Reflecting on the Road We've Traveled. Diane Daly MacLeod, Senior Partner, Intellectual Property at Foga Daily, Jamaica. Saint Lucia. Page 15. Glitz Law Attorneys at Law, Legal Practitioner Profile and Article. IP in St. Lucia, Challenges, Opportunities, and Insights. Natalie E. Glitzenhan Augustine, Legal Practitioner at Glitz Law, St. Lucia. Page 19. Nicholas John and Co., Partner Profile and Article. St. Lucia, The Case for 2 More Geographical Indications. Leon Theodore John, Partner and Head of IP at Nicholas John and Company, St. Lucia. Page 23. Amicus Legal, Senior Associate Attorney Profile and Article. Spotlight on St. Lucia. Nurturing the IP Landscape, The Road to Excellence. Desma F. Charles, Senior Associate Attorney at Amicus Legal, St. Lucia. Turks and Caicos Islands. Page 27. Miller Simons O'Sullivan, Trademark Administrator and Partner Profiles. Deborah, Yvonne, Garland and Louise Malcolm, Turks and Caicos Islands. Cayman Islands. Page 31. HSM IP Limited, Senior Intellectual Property Manager Profile and Article. From Code to Creation, RE's Growing Influence on Law and Intellectual Property in the Caribbean. Mrinali Menon, Senior Intellectual Property Manager at HSM IP Limited, Cayman Islands. Trinidad and Tobago. Page 36. Terita Kallu Law, Attorney at Law Profile and Article. Building an IP Ecosystem, Lessons from Trinidad and Tobago. Terita Kallu, LLM, LEC, LLB, Attorney at Law at Terita Kallu Law, Trinidad and Tobago. Haiti. Page 41. Abdelrazak and Associates, Founder and Partner Profile and Article. The Impact of Copyright on Cultural Production in Haiti, Legal Framework, Opportunities, and Global Potential. Vanessa Abdelrazak, Founder and Partner at Abdelrazak and Associates, Haiti. Grenada. Page 45. Danny Williams and Co., Attorney at Law Profile and Article. Grenada's IP Evolution, Protecting Innovation in the Spice Isle. Daniela C. Williams Mitchell, Attorney at Law at Danny Williams and Co., Grenada. Page 49. Sion and Associates, Attorney at Law, Notary Public Article. Culture, Creativity, and Commerce Intellectual Property in Pure Grenada, the Isle of Spice. Linda Dolland, Attorney at Law, Notary Public at Sion and Associates, Grenada. Anguilla. Page 51. Severi Mon Suarez, Managing Partner Profile and Article. Transforming Trademark Law in the Caribbean, New Legislation Empowers Brand Owners. Keisha Fleming Lake, Managing Partner at Severi Mon Suarez, Anguilla. Page 6. The Caribbean IP Annual 2025 Opening Statement. Hugh St. J. Moses, OBE, Director, IPCA, Cayman Islands. www.ipca.website. The Intellectual Property Caribbean Association, IPCA, is honored to introduce the inaugural edition of the Caribbean IP Annual, a publication dedicated to promoting and spotlighting excellence in intellectual property across the Caribbean region. Over the years, the Caribbean region has remained a key player in the global IP landscape. Each Caribbean nation brings its own unique culture and creativity, which has inspired businesses and creators to focus on protecting their innovations and works. This has resulted in a growing range of IP protections across diverse industries, from agriculture and tourism to entertainment, with artificial intelligence and technology now leading the way in innovation. With this growth comes the important responsibility to prioritize and generate awareness about IP protection. Each jurisdiction has formulated its own set of IP laws and regulations, making it essential for stakeholders and industry members to stay informed about local nuances to best protect their IP. While the IP industry in the Caribbean has made significant progress, there are still opportunities to further enhance the timely and efficient implementation of laws in the region. As the region continues to evolve, IP plays a pivotal role in helping businesses thrive, both domestically and internationally, which includes the importance of protecting brand identities, trademarks, and logos, making the need for IP practice to match the ever-expanding global market. Some jurisdictions have made significant progress in enhancing and implementing advanced frameworks, while others are addressing a few obstacles to updating administrative procedures, with a focus on improvement and progress. IPCA believes that this forum will serve as an outlet to inform, inspire, engage, and keep Caribbean communities up to date with the changes and developments in the world of IP regulations. IPCA was established in 2014 to help promote IP rights in the Caribbean and establish a forum for improved communication among IP practitioners. IPCA's network includes over 23 countries and 50 member firms' IP registries. IPCA continues its efforts to encourage interactions with IP through various discussions and panels, both offline and online, including representation at various international IP conferences and an annual general meeting. A few member firms of IPCA are participating in this publication. Details about joining IPCA and the work done can be accessed on the association's official website, https://ipca website. We are excited for this publication to become one of the leading platforms connecting the IP practice of the Caribbean with the rest of the world. This inaugural edition aims to shed light on a wide range of upcoming and interesting updates currently spreading waves in the Caribbean. Topics encompassing artificial intelligence and IP, legislative updates, trending news, and impactful innovations will be presented alongside in-depth insights from key industry professionals and expert contributors. The Caribbean IP Annual will serve as a crucial resource, fostering collaboration and knowledge exchange across borders while highlighting the unique legal landscape, enforcement challenges, and economic potential of the region's IP sector. By bringing together voices from leading law firms, businesses, and government bodies, this publication will play a pivotal role in shaping the future of IP in the Caribbean. With the rise of technology-backed companies, IP has taken various forms and is not limited to seeking only trademark, patent, or design protection. A creation now comes in different shapes, sizes, and forms, and the Caribbean is home to a unique blend of music, fashion, art, and culture, all of which are a unique representation of the many territories that form the Caribbean. Ultimately, whether you are a local entrepreneur or a multinational corporation seeking IP assistance in the Caribbean, we hope this publication serves as a helpful know-how guide for your business. We appreciate and wholeheartedly welcome Northon's media PR and marketing taking this much-needed initiative to create this platform. As the global economy continues to evolve, it is important that our Caribbean jurisdictions continue to embrace change. With regional cooperation and education, IP in the Caribbean has an exciting future. With that, we hope this publication continues to foster open dialogue for regional unity and collaboration. We appreciate your interest, as a reader, in learning more about the dynamic world of IP and its contributions in the Caribbean. Puerto Rico. Page 7. Profile. Name, Eugenio J. Torres Oyola. Law firm, Ferri-Woli. Position: Managing Partner and Co-Chair. Country: Puerto Rico. Website: www.ferraiwoli.com. Eugenio J. Torres-Oyola is a capital member, managing partner of the firm, and the co-chair of its intellectual property practice group. He concentrates his practice on IP and technology, and entertainment law. Since 2001, Eugenio has been an adjunct professor at the University of Puerto Rico School of Law, where he has taught elective courses in patent law practice, cyber law, and international patent law practice. He is currently teaching an intellectual property and entrepreneurship clinic course that is certified by the USPTO under its law school certification program, having received one of the first certifications in the United States. Eugenio is a frequent and prominent speaker at events and seminars relating to IP and technology law. As a result of his widely recognized knowledge and experience, he is actively involved in leadership positions in several associations and groups promoting the development of the technology industry in Puerto Rico. He is a member of the board of directors of the Puerto Rico Information Technology Cluster. He is a founding member and a past president of the Entrepreneurs Organization, EO, Puerto Rico chapter. Currently, he serves in EO's Regional Council as the Governance Director for the Central America and Caribbean region, as well as in the Global Governance Committee. Eugenio is an active promoter of high-impact entrepreneurship and angel investing in Puerto Rico. He has collaborated for many years with Grupo Guayacan, where he also sits on the board of directors, as well as other non-profit entities such as the Puerto Rico Science and Technology Trust, Small Business Technology Development Center, C3 Tech, and Colmena 66. Professional recognition. From 2010 to 2013, Chambers & Partners Latin America ranked Eugenio as a Band 1 attorney in IP for Puerto Rico. In 2014, he was recognized as a star individual, the only attorney in Puerto Rico with such recognition in any practice area. He retained that ranking from 2014 to 2022. Fellow Hispanic National Bar Association, Microsoft Intellectual Property Institute 2017-2019. World Trademark Review 1000, 2015-present. Who's Who Legal, Trademarks 2013-present. Who's Who Legal. Patents 2017-present, only lawyer in Puerto Rico. Recognized by Best Lawyers International as the best lawyer in Puerto Rico for intellectual property law, 2013-present. Best Lawyers Lawyer of the Year Intellectual Property Law 2014 to 2015. Ranked as one of the top 10 patent law firms in the Caribbean by the Patent Lawyer magazine, 2020. Managing Intellectual Properties IP Stars 2019-present, only lawyer in Puerto Rico 2019-2020. Young Entrepreneur of the Year for 2010 by the Puerto Rico Sales and Marketing Executives Association. American Bar Foundation Life Fellow since 2021. Education. Massachusetts Institute of Technology Entrepreneurial Masters Program 2023. EO Global Leadership Academy 2022. Massachusetts Institute of Technology Sloan School of Business Entrepreneurship Development Program, 2009. University of Puerto Rico School of Law, J.D., 1998. Massachusetts Institute of Technology, B.S. in Environmental Engineering, 1993. Page 08. Article. Disclaimer: images and references related to this article can only be seen in the print and digital versions of the magazine. Striking a Balance, IP and Data Protection in Puerto Rico's Digital Economy. Written by Eugenio J. Torres-Oyola, Managing Partner and Co-Chair, Intellectual Property at Ferraiwoli, Puerto Rico. In today's economy, intellectual property, IP, and privacy are central concerns that shape the landscape of innovation and commerce. IP encompasses creations of the mind, such as inventions, literary and artistic works, and designs. It is the basis for fostering innovation, rewarding creators, and driving economic growth. However, the digital age has brought new challenges in protecting IP rights, with problems such as piracy, counterfeiting, and unauthorized use proliferating on various online platforms. At the same time, privacy concerns have increased due to companies' and governments' widespread collection and use of personal data. The recent wave of growth in emerging industries in Puerto Rico and the development of new technologies have awakened a series of concerns among stakeholders about consumers' privacy amid the constant flow of information to which individuals are exposed. In this context, this past year, there has been discussion and lobbying in Puerto Rico in favor of protecting the information collected from consumers. The Puerto Rico legislative branch authored two critical pieces of legislation regarding data protection and security that companies and business entities in Puerto Rico must hold dear to do business in Puerto Rico. Cybersecurity Act. On January 21, 2024, the Governor of Puerto Rico signed Act No. 40 of 2024, also known as the Cybersecurity Act of the Commonwealth of Puerto Rico, Cybersecurity Act. This act imposes significant security conditions applicable to the public sphere and private companies that work with the government and/or receive public funds. The Cybersecurity Act establishes a public policy to secure government data, a comprehensive framework to ensure cybersecurity in the government of Puerto Rico, government, and addresses access control, data protection, threat prevention, and collaboration with service providers. The provisions of the Cybersecurity Act apply to the executive branch, to any natural or juridical person that does business or has contracts with the government, private persons that perform public functions and services, only concerning the public functions and services performed, to any exercise of public or private administration in which public funds or resources have been dedicated or invested, directly or indirectly, or over which the authority of any public servant has been exercised, concerning the data generated as a product of such activities, concerning parties. The Cybersecurity Act codifies that the concerning parties must establish mechanisms to stop inappropriate traffic on the Internet and a security policy to prevent access to websites with inappropriate content, such as pornographic content, malware, phishing, and other threats. Establish layered control mechanisms to reinforce confidentiality, integrity, and information authorization. Establish policies for appropriate use of equipment and information systems, reinforced with administrative and technical controls and control mechanisms for accessing the information network. Encrypt confidential information. Encryption is required based on the best recommendations of the National Institute of Standards and Technology, NIST, for the confidentiality and integrity of information. In addition, technical controls must be established to enforce these policies. Establish virtual private networks, VPNs. Remote connections to the government can only be made through VPNs or other virtual private network software contracted exclusively for official use. Comply with minimum security standards and principles before developing programs or applications. Agencies accepting credit card payments must comply with payment card industry best practices and data security standards. If a third party provides the service, the third party must provide the agency with a PCI DSS compliance report or best practice before the agency can contract. Establish multi-factor authentication, MFA, for all users, especially after classifying data by criticality. Install automatic controls to detect unwanted programs that may affect information security. Concerning parties covered by the new Cybersecurity Act should, 1. Review the new Cybersecurity Act and the specific requirements that apply to its particular case. 2. Conduct an internal assessment to determine the degree of current compliance with the requirements of the Cybersecurity Act and identify any existing compliance gaps. 3. Create a plan to comply with the requirements of the Cybersecurity Act. The Cybersecurity Act establishes penalties for non-compliance and empowers the Puerto Rico Innovation and Technology Service Office to adopt regulations necessary to comply with the established public policy. The Cybersecurity Act became effective immediately after its approval. However, the government will have 6 months to finalize all the necessary procedures to comply with the provisions of this Act. Bill No. 1548. Puerto Rico is moving towards more secure and strict regulations on consumer data collection. Just recently, both bodies of the Puerto Rico legislative branch approved the bill of the House No. 1548, Bill No. 1548, which outlines new standards for data collection, consequences for businesses that cannot protect user data, and rights of the Puerto Rican consumers. More specifically, Bill No. 1548 declares as a public policy of the government of Puerto Rico the protection of the personal data of its citizens, used in the commercial interaction between consumers and companies, businesses, or commerce, which in the exchange of goods and services require the personal data of their clients for databases, profiles, or any commercial use. Among the new standards that companies and businesses will have to adhere to are: every consumer shall be entitled to and shall be advised that the company, business, or trade with whom they do business by offering goods and services requires the personal information of the consumer to be used, stored, and safeguarded. The consumer should provide informed consent and be aware of the company's use of the personal information it collects from the consumer for database storage, data repositories, prospect lists, future promotions, contests, sweepstakes, or any other commercial use. The informed consent must be unequivocal, the product of a warning in broad, explicit language, and must be found in a visible place in any document, contract, website, or electronic application. A consumer shall have the right to request that a company, business, or trade delete any personal information that the company has collected. A few exceptions apply. A company or business cannot discriminate against consumers for exercising their rights under this Act. This includes denying goods and services to the consumer, charging different prices or rates for goods or services, including by refusing discounts or other promotions applicable to the general consumer as a penalty, and providing an inferior level or quality of goods or services. Businesses and companies shall make available to consumers 2 or more designated methods for submitting requests, complaints, or claims, including, at a minimum, a telephone number, email, and mailing address. Businesses and companies shall store the consumer's data for no more than 24 months. A few exceptions apply. Companies and businesses in Puerto Rico must be aware of these standards, which intend to enhance privacy rights and consumer protection, and take the necessary measures to comply with them. Bill No. 1548 is pending the Puerto Rican governor's signature to become law. Once it is signed, it enters into force immediately. Businesses should review their data inventory, collection, and sharing practices to determine if their privacy methods comply with Bill No. 1548.
Page 10. Advertisement. Ferraioli. www.ferraioli.com. Call 7877667000.
Jamaica. Page 11. Article. Disclaimer: images and references related to this article can only be seen in the print and digital versions of the magazine. 3 decades of intellectual property transformation in the Caribbean, reflecting on the road we've traveled. By Diane Daly MacLeod, Senior Partner, Intellectual Property, Foga Daly, March 25, 2025, Jamaica. When I embarked on my journey into intellectual property, IP, law and administration several years ago, I could never have imagined what today's Caribbean IP landscape would look like. At that time, awareness about the importance of IP rights was just emerging in the Caribbean, and IP was not a national priority. The coming into force of the World Trade Organization's, WTO, trade-related aspects of intellectual property rights, TRIPS, agreement in 1995 propelled Caribbean countries into a world that I believe we were not quite prepared for. It also coincided with a significant milestone in my career, completing my master's degree in comparative law, with a specialization in international copyright and intellectual property, at McGill University in Quebec, Canada. As I landed back on my island that same year, I headed to the office of the Prime Minister to become the first legal director and head of Jamaica's copyright unit a few months later. My predecessor was a retired librarian and educator, and my colleague, who is now the head of the Caribbean section, Division for Latin America and the Caribbean at the World Intellectual Property Organization, WIPO, and I found ourselves navigating the complex terrain of copyright policy amidst active trade negotiations, including those surrounding the Free Trade Area of the Americas, FTAA. Venturing into the related area of industrial property was inevitable for me, as the implementation of Jamaica's obligations under the TRIPS agreement demanded a comprehensive policy approach. I would find myself over the next 5 years helping to chart a course for the government to bring all aspects of IP under one ministerial portfolio and ultimately one office, the Jamaica Intellectual Property Office. Come with me on a bird's-eye journey to explore where things stood when I joined the copyright unit and how far Jamaica and indeed our Caribbean neighbors have come 3 decades later. Copyright has played a central role in shaping IP policy and legislation in Jamaica. This comes as no surprise, given our vibrant orange economy. Policy discussions and debates around IP have predominantly focused on copyright, regardless of the bill under consideration. I remember noting this once when a parliamentarian passionately advocated for copyright when the Layout Designs, Topographies bill was being tabled. 2. While trademark registrations had already been recognized as a revenue earner for Jamaica's Companies Office, patents and designs were back-burner issues. A lone desk officer in the Ministry of Industry and Commerce processed patent applications under the archaic Patent Act of 1857, while industrial designs filings under the Designs Act of 1937 were few and far between. It was the advocacy of Jamaica's vibrant entertainment industry which served as a catalyst for Jamaica's accession to the Berne Convention for the Protection of Literary and Artistic Works, 1886, and the Rome Convention for the Protection of Performers, Producers of Phonograms and Broadcasting Organizations, 1961, and the repeal of the Copyright Act of 1911, UK's Imperial Copyright Act, resulting in a robust Copyright Act in 1993.3. These major developments set Jamaica on a path of transformation of its IP landscape, with the TRIPS agreement serving to bring into focus the other areas of IP that needed attention. Like Jamaica, most Commonwealth Caribbean countries had joined the WTO in 1995 with outdated IP laws and low participation in the international IP framework. Some countries had joined WIPO and the foundational IP treaties, the Berne Convention, and the Paris Convention on Industrial Property, 1883, a few years before, and some in tandem with their membership in the WTO. 4. At the time, Trinidad and Tobago and Jamaica were very active in the international IP arena, often being the only English-speaking Caribbean participating in discussions on groundbreaking treaties like the WIPO Copyright Treaty and the WIPO Performances and Phonograms Treaty, together the WIPO Internet Treaties, adopted in 1996, which both countries signed and subsequently acceded to. As Caribbean countries began to appreciate the critical role of IP in trade relations, efforts to modernize outdated laws and engage with the international framework of IP rights protection gained momentum. The participation of other Caribbean nations at forums such as WIPO increased considerably, paving the way for the inaugural WIPO ministerial-level meeting for Caribbean ministers with responsibility for IP hosted by the Government of Jamaica in June 1999. This meeting had several objectives, including developing a regional strategy for collective management of copyright, which led to the formation of the Caribbean Copyright Link, CCL, providing support services to national collective management organizations, CMOs. 7. By then, Jamaica had 2 indigenous CMOs, the Jamaica Association of Composers, Authors and Publishers, JACAP, representing the rights of authors, composers, and publishers in their musical works, and the Jamaican Copyright Licensing Agency, JAMCOPI, representing authors and publishers of printed published works, both established in 1998. In the ensuing years, with WIPO's technical assistance, Caribbean countries began to transition trademarks, designs, and patent administration from companies and corporate government registries, even the Registry of Births and Deaths, to dedicated IP offices. 8. Indeed, these aspects of IP were hitherto treated as distinctly separate activities, and it is fair to say that copyright administration was largely considered a private concern, thus no need for a government office dealing specifically with copyright. Jamaica stood out with its emphasis on copyright and related rights. By the turn of the century, Jamaica had revamped its Copyright Act, via amendments in 1999, updated its Trademarks Act, via amendments in 1999 and 2001, passed a new Layout Designs, Topographies Act, and consolidated copyright, industrial designs, layout designs, geographical indications, trademarks, and patent administration under one office, namely, the Jamaica Intellectual Property Office, JIPO, 2001. 9. The establishment of JIPO, for which I served as the coordinator, marked another milestone in my career. It signaled my transition from being a government expert and special advisor on IP to heading up our IP department at our boutique law firm, Foga Daly. The firm was co-founded by my law partner Nicole Foga, who was the former government advisor on telecommunications and also played a key role in the establishment of JIPO. Staying on top of developments in IP has been essential to our law practice, and my early involvement on the JIPO advisory board provided a unique opportunity to continue pioneering work that merged the broad governmental perspectives with practical insights as a practitioner. The WIPO ministerial level meetings would become a regular feature in the coming years, with WIPO partnering with national IP offices around the world to set the agenda for collaboration between governments for the progressive development of IP. The achievements are too numerous to mention here, but I was honored to be a part of earlier ministerial meetings which helped to shape cooperation between Caribbean governments and WIPO and set the stage for future collaboration. As the Caribbean community, CARICOM, began to respond collectively to the requirements of the TRIPS Agreement, the FTAA, bilateral agreements, and other IP-related trade negotiations, the CARICOM Treaty was updated by the revised Treaty of Chaguaramas to include the CARICOM single market and economy. Concluded in the Bahamas on July 5, 2001, the revised treaty mandated a regional approach to IP policy and administration and set CARICOM countries on a path to strengthen their IP regimes by joining the critical IP treaties, pursuing regional administration of industrial property, and embarking on a process of modernization and harmonization of IP laws. 12. The region would cooperate again with the negotiations of the Economic Partnership Agreement with the European Union and, post-Brexit, the United Kingdom. 13. The EPAs set even higher standards of IP protection than the TRIPS Agreement, challenging CARIFORUM countries to enter new international arrangements, including the Patent Cooperation Treaty, 1978, and the Madrid Protocol concerning the international registration of marks, 1989. 14. While Jamaica was TRIPS compliant with respect to copyright, trademarks, and geographical indications, having passed the Protection of Geographical Indications Act in 2004, it was lagging on patents and designs. This landed Jamaica on the U.S. Special 301 watch list for inadequate IP rights protection, opening up Jamaica to possible trade sanctions from the U.S. Work had started on a draft Patent and Designs Act shortly after signing the WTO agreement, but that draft went through several iterations between 1996 and 2019 until finally, the Patents and Designs Act, also covering utility models, was passed. The Patents and Designs Act was the first law to be enacted in 2020, resulting in Jamaica's removal from the U.S. Special 301 watch list. The Act implements the Paris Convention and the PCT, and, as of February 2022, when the Act came into operation, international applicants have been able to designate Jamaica. The year 2022 was also significant to trademark practitioners as a substantive update to the Trademarks Act was accomplished through the promulgation of comprehensive trademarks rules, this time to implement the Madrid Protocol, to which Jamaica acceded 3 months prior to its entry into force on March 27, 2022. Jamaica did not enter the Madrid Protocol unprepared, thanks to the thoughtful intervention of local trademark attorneys who urged a cautious approach and lobbied for the proper groundwork to be laid for implementation through robust amendments to the Trademarks Act. Trademark attorneys aimed to temper the expectations of local proprietors who perceived the Madrid Protocol as a universal solution for global brand protection and enforcement. Interestingly, to date, only a handful of local proprietors have gone the protocol route. In relation to copyright, by 2015, the government revamped its Copyright Act of 1993, implementing the WIPO Internet Treaties and introducing an unprecedented copyright term extension of up to life plus 95 years, albeit met with mixed reviews. There are now 3 local CMOs, JACAP, JAMCAPI, and the Jamaica Music Society, JAMMS, representing the rights of record producers and performers, incorporated in 2006, and the Caribbean Reproduction Rights Organizations Agency, CAROSA, formed in 2018 by the 5 Caribbean RROs led by JAMCAPI, the Trinidad and Tobago Reproduction Rights Organization, TTRRO, the Barbados Copyright Agency Inc., BCOPI, the Belize Copyright Licensing Agency, BECLA, and the Eastern Caribbean Copyright Licensing Association, ECCLA, incorporated in Saint Lucia to serve the OECS member states. Despite setbacks and challenges, like some of its Caribbean counterparts, Jamaica now boasts a suite of modern IP laws, an upgraded IP office, a strong cadre of IP legal professionals supporting its robust framework, an organized system of collective management, and a more engaged and discerning public. With the opportunities and challenges presented by the growing use of generative artificial intelligence and anticipated amendments to the Copyright Act, including plans to reduce the 95-year copyright term, the next decade for IP is poised to be undeniably transformative.
Page 14. Advertisement. Caribbean Trademark Services. Law Office of George C. J. Moores, PA. Over 40 years of one-stop trademark services in the Caribbean. www.caribbeantrademarks.com. Telephone 1-561-833-9000. Fax 1-561-833-9990. Email ip@caribbeantrademarks.com. Address 2855 PGA Boulevard, Palm Beach Gardens, Florida 33410.
Saint Lucia. Page 15. Profile. Name, Natalie E.G. Augustine, Esquire. Law firm, Glitzlaw. Position, legal practitioner, Notary Royal. Country, Saint Lucia. Website, www.glitz-law.com. Natalie Glitzenhern Augustine, B.A., Honours, CPE, TEP, C. DIR is a UK-born, German and Caribbean-raised graduate of the University of Warwick, B.A. Honours. In International Studies with German, and the University of West London, Common Professional Examination in Law and Bar Finals, who founded the law firm Glitzlaw, formerly Glitzenhern Augustine and Company, and its affiliated firm of Registered Agents Financial and Corporate Services Limited. Fincos, in 2000 in Saint Lucia. Natalie, a barrister admitted to the Inns of Court at Middle Temple in London, has more than 29 years of practice in the legal arena under her belt. She heads the corporate and commercial departments of Glitzlaw, a general civil law boutique practice with an emphasis on IP matters, trademark, industrial design and patent registrations, company incorporations and administrations, tax structuring, conveyancing, wills, trusts, successions and mergers and acquisitions. In tandem with this, she directs the affairs of Fincos, a duly licensed entity in the St. Lucian International Financial Services arena, specializing in the establishment of international business companies, IBCs, with global use and reach, as well as procuring and managing licenses for regulated entities such as multinational banks and insurance companies. A member of INTA, IPCA, and Marques, she has, over the years, carved out a niche in the local Saint Lucian IP sector, honing and improving her skills through attendance at workshops and conferences and supporting her clients when trademark applications give rise to oppositions and conflict negotiations or when litigation becomes necessary, generally culminating in mutually satisfactory resolves or outright successes. Over the last 25 years, with the efforts and support of her eager and competent in-house IP team, and as a result of the confidence placed in her by regional and international service providers and end users of the sector, Natalie has grown Glitzlaw's IP portfolio from a small initial collection of local and connected clients to an impressive multinational client base to include international brands such as BMW, Polo Ralph Lauren, and Vans. Wearing her professional hat, Natalie, who is also a Notary Royal, serves and has served on the board of directors of local and regional corporations, such as Invest Saint Lucia, formerly the National Development Corporation, and Mayberry Jamaican Equities Limited. Always keen to be of service, she gives and has given her time to the St. Lucia Bar Association as well as being the chairperson and founding member of both the local branch of STEP, formerly the Society of Trust and Estate Practitioners, and the International Financial Services Association of St. Lucia. Regionally, she is the vice chair of the STEP Caribbean and Latin American Regional Committee. She is the current chair of the Health Service Complaints and Conciliation Commission in Saint Lucia. Fluent in German, with a comprehension of Spanish, Natalie enjoys hiking, traveling, and entertaining in her spare time. Page 105. Article. Disclaimer: Images and references related to this article can only be seen in the print and digital versions of the magazine. IP in St. Lucia: Challenges, Opportunities, and Insights. In an insightful conversation with Zafira Hudani, a reporter at Northon's Media PR and Marketing Limited, legal expert Natalie G. Augustine delves into the evolving intellectual property landscape in St. Lucia. From her early fascination with trademarks to her firm's dedication to guiding startups and established businesses through IP protection, she underscores the importance of securing creative and commercial assets. She discusses the challenges of registering trademarks and patents in St. Lucia, the country's copyright framework, and the impact of international treaties. With digital innovation on the rise, she envisions a future where technology enhances IP enforcement, ensuring that creators and businesses can safeguard their rights more effectively. Zafira: Natalie, could you start by telling us about your background and expertise in IP law? How did you become involved in this field? Natalie: The absolute start for me dates back to when I was a child, when my stepfather, whilst driving, would point out car logos for me to guess the make. This then extended into billboard signs. I learned from a tender age that these signs differentiated one car or item from another, making them stand out and catch my eye. When I began my legal career, the firm I first worked with gave me the opportunity to witness the registration of a mark from start to finish for a client, and my interest was piqued. Since then, as with most practitioners, my interest in IP, not having been a possible elective back in law school, has been augmented through reading, certification, and years of on-the-job experience, along with conference and workshop attendance. Zafira: How does Glitz Law support individuals and businesses in protecting their IP rights in St. Lucia? Natalie: Our boutique civil law firm, Glitz Law, is always keen to work with startups, where we have the opportunity to guide them through their incorporations, business structuring, and licensing. So, extending this to advising on IP protection is a natural add-on. And for those overwhelmed by the initial outlay to bring their business idea to fruition, we nevertheless provide guidance by attending forums and agencies set up to assist fledgling enterprises, where we often offer advice without charge. For companies or individuals with more seasoned products, ideas, or services, it is often more challenging to convey the possibility of losses or damages that can occur. This risk arises if, after all of their years of crafting their product or trade, they fail or refuse to safeguard the same through registration of a now-known mark, methodology, system, or process. Someone else, with just a slight tweak to the same, can proceed to do so in their stead, and that single modification could be what was missing to capture a wider and more lucrative audience, and in so doing, diminish the value of the first-in-time creation. Zafira: What are the key challenges businesses face when registering trademarks and patents in St. Lucia, and how does your firm help navigate these challenges? Natalie: At long last, Saint Lucia has moved with the times and is slowly automating a number of government services, including the registration of companies and IP. However, as with most things new, the teething problems are never-ending. Even so, without the assistance of a legal practitioner, registering a trademark or patent on one's own accord would be a daunting exercise for a business. That is where firms like Glitz Law come in to assist clients with the process, serving as the liaison between the law and the registry. We attend not only to registrations and the necessary searches but also oppositions and renewals, all of which often come with their own challenges. Zafira: Copyright protection is essential for creators. Could you share insights into St. Lucia's copyright framework and how creatives can ensure their work is legally safeguarded? Natalie: Recently, I had the pleasure of sharing the stage with one of Saint Lucia's best-known soca artists at a business mixer of the Youth Economy Agency, at which he told his story of having his music stolen. He had presented it to be listened to for the purpose of seeking assistance to publish the same, but instead of taking him and his rhythm on as an artiste, he only later discovered that his creation was being used by another artiste without his permission. Many in the audience stopped fidgeting and listened intently, realizing how easy it would be to find themselves in a similar position. He implored them to learn from his mistake and seek protection for their creations at the earliest possible stage. Are they? Who knows, only one person in the audience has contacted me since, so I only hope that the others have at least sought the assistance of legal colleagues to ensure that they acquire protection under the Copyright Act Capital 13.07 of the laws of Saint Lucia, enacted to afford better protection for literary, dramatic, musical, artistic, and other works and creative products, and to make provision as to the rights of performers and others in performances. Zafira, St. Lucia is a member of various international IP treaties. How do these agreements influence IP protection for local businesses and international entities operating in St. Lucia? Saint Lucia is a party to 37 international treaties such as Rome, Paris, Bern, and TRIPS, but if I can be totally honest at present, most of the treaties only serve to effectively guide the manner in which protection is registered. But until sufficient resources are on hand to police registration and enforce penalties, Saint Lucia may see little benefit from accession to the same, particularly if the inability to reciprocate promised protections comes with onerous penalties or disqualifications. Positively, for example, as a member of the Bern Convention, Saint Lucian artistes and creatives who, since 1993, do in fact seek legal advice to protect their copyright locally, will very likely also be guided for a mere $60 to register their works under the Convention for international protection to be afforded them. Conversely, since Saint Lucia is not a party to the Madrid system of trademark registration, local businesses effectively have to register their marks individually in other jurisdictions to be afforded protection there. This is the reason why international entities and brands must register directly here. Zafira, with the rise of digital innovation, how do you see the future of IP enforcement evolving in St. Lucia, and what role does your firm play in shaping this landscape? Natalie, once the Saint Lucian DigiGov system is fully enabled to allow for searches to be conducted online, this will enable brand owners to effectively monitor conflicting registrations to their protected marks, and through the use of AI technology, creatives are in the position to feed their work into search tools to ensure that nothing infringing is in circulation or determine that it is not in fact they who have subconsciously adapted someone else's work. Zafira, Natalie, it's been a pleasure speaking with you. Your expertise in IP law and your commitment to supporting businesses and creatives in St. Lucia are genuinely inspiring. Thank you for sharing your time and insights with us.
Page 18. Advertisement. Glitz Law Attorneys at Law. Consider it done. Our services. IP services. Corporate and commercial law. Patents. Company formation and administration. Conveyancing and notarial work. Trusts. Wills and successions. Contact us to schedule a consultation and start your journey towards legal success. www.glitz-law.com. Natalie.augustine@glitz-law.com. Phone +1 75845163555. Suite number 1, first floor, Bourbon House, Bourbon Street, P.O. Box 1, 695 Castries, LC 04101, St. Lucia.
Page 19. Profile. Name, Leon Theodore John, LLB, TEP. Law firm, Nicholas John and Company, St. Lucia. Position, partner and attorney at law. Country, St. Lucia. Website, www.stlucialawyer.com. Profile. Leon Theodore John is a St. Lucian barrister with over 35 years of expertise in IP law. She holds a Bachelor of Laws from the University of Wolverhampton and a postgraduate diploma in law, the Bar Vocational Course, from the University of Northumbria, Newcastle, UK. Called to the Bar of England and Wales in July 2005 as a member of the Honourable Society of Lincoln's Inn, she was also admitted to the Bar of the Eastern Caribbean Supreme Court in St. Lucia in September the same year. Leon began her legal journey as a legal secretary in 1989 and became a certified paralegal in 1993. She then co-founded the law firm of Nicholas John and Company. In 1993 with her husband and law partner, Nicholas John. Upon completing her formal legal training, she returned as partner and head of IP in the firm. Returning to the firm as head of IP in 2005, she birthed the development of an IP department with dedicated IP staffing. With renewed vigor, Leon was driven to develop a niche market for Nicholas John and Company, and to dominate the IP industry in Saint Lucia. She was sure that active membership in and presence at global IP organizations, such as INTA and Marques to begin with, were her best tools of trade in terms of networking. She admits that was not an easy task, as she reminisced about the long nights trotting from cocktail receptions during INTA's annual meetings and the annual Marques conferences. The hours were long and hard on the feet, she recalls. However, the determination was there, and the many nights of hard work paid off. Nicholas John and Company boasts the largest IP client portfolio in Saint Lucia. The firm's global IP clients span all industries, ranging from luxury consumer goods such as clothing, jewelry, and cosmetics, to world-famous brands and food chains, as well as the automobile industry, hotel chains, the tobacco industry, spirits, non-alcoholic drinks, beers, and energy drinks. Leon is respected as the most formidable figure in IP law practice in Saint Lucia, and this is not by chance. She has worked long and hard for that coveted title. Her deep commitment to promoting IP awareness in Saint Lucia, particularly in trademarks and copyright, has benefited countless entrepreneurs and strengthened ties with the Registry of Intellectual Property. Leon continues to drive the firm's reputation for world-class legal services. Beyond IP, she excels in civil litigation, corporate law, succession planning, and international financial services, holding the prestigious Trust and Estate Practitioner (TEP) designation and a certificate in offshore financial services from Offshore Investment, Jesus College, Oxford. Public service. Leon's contributions extend beyond practicing law. She has held key positions shaping Saint Lucia's development. Director, Development Control Authority, 2006 to 2009. President of the Senate, 2010 to 2012. Speaker of the House of Assembly, 2016 to 2018. Chair, Constituencies Boundaries Commission, 2016 to 2018. Minister Councillor and Chargé d'Affaires, Saint Lucia High Commission, London, 2018 to 2022. Personal interests. A passionate epicure, Leon enjoys cooking and baking, gardening, and beekeeping in her spare time. Her dedication to her craft and her community is a testament to her unwavering commitment to excellence. Nicholas John and Company. Where legal expertise meets client dedication. Page 20. Article. Disclaimer: images and references related to this article can only be seen in the print and digital versions of the magazine. Saint Lucia, the case for two more geographical indications. Written by Leon Theodore John, partner and head of IP at Nicholas John and Company, Saint Lucia. In November 2024, Saint Lucia saw the registration of its very first geographical indication, GI, under the Geographical Indications Act No. 4 of 2000. This first GI secured the registration of Saint Lucia rum. What does this mean for a small island development state like ours? The rums produced by St. Lucia Distillers Limited have captured many prestigious awards in various categories, from gold to bronze, in the global rum industry over the years. It is hoped that the now registered GI will add greater value to and further enhance the export potential of all rums marketed under and containing the Saint Lucia rum designation. Perhaps of even greater significance is that this first registration opens the gateway to new and greater trade opportunities. Saint Lucia cacao. Saint Lucia boasts having very rich and fertile volcanic soil, which lends to the uniqueness of most of its agricultural products. Saint Lucia has a rich, deep history of producing some of the world's best cocoa and chocolate. Dating back to the early 1700s, Saint Lucia exported its cocoa beans to Europe, where it was transformed into the world's finest chocolates. Saint Lucia's cacao is unmatched, delivering a flavor so distinct and extraordinary, it sets a new standard for chocolate lovers worldwide. With a fast-growing and thriving chocolate industry, the island already boasts over 6 chocolate factories. The cacao produced in Saint Lucia is so distinct and unique that it has made its way to famous brands such as Cadbury and Hotel Chocolat. In 2015, the luxury brand Hotel Chocolat scooped the most awards at the prestigious world event, the 2015 Academy of Chocolate Awards, 2 of which were for products made exclusively from Saint Lucian cocoa. The luxury chocolate brand, which not only owns a cacao estate in Saint Lucia, but also a chocolate factory, was awarded the silver in the Bean to Bar under 80% category for its Robot estate, located in Soufriere, Saint Lucia, single coat, Bord du Lac 70% cocoa, and the bronze in the Best Flavored Milk Bar category for its Saint Lucian 65% milk Earl Grey. With such unique, high-quality cacao, the time is ripe for Saint Lucia cacao growers and chocolate factory owners to take the next step and secure that next GI for Saint Lucia cacao. Choiseul pottery stands out. The southwestern village of Choiseul in Saint Lucia is renowned for its exceptional clay-rich soil, a direct result of the island's volcanic origins. Geologically, Saint Lucia was formed through intense volcanic activity. Located near some of the island's ancient volcanic centers, Choiseul has soil that has been enriched over centuries by volcanic ash and rock. This soil, primarily derived from andesitic and basaltic materials, breaks down into fine-grained clay, making it highly suitable for pottery and ceramics. One of the defining characteristics of Choiseul's soil is its high content of clay minerals such as kaolinite and montmorillonite. These minerals contribute to the soil's smooth texture, plasticity, and workability, which are essential qualities for molding and shaping clay products. The presence of iron oxides gives the clay a rich reddish or brownish hue when fired, adding to the distinctiveness of Choiseul's pottery. These geological advantages have made Choiseul the heart of Saint Lucia's traditional pottery industry. The superior quality of its clay allows artisans to create durable, aesthetically appealing ceramics that have been cherished for generations. The clay pottery tradition in Choiseul dates to the Amerindians. These South American indigenous people were the first inhabitants and known settlers of Saint Lucia. This is supported by archaeological evidence of Arawak settlements dating back to as early as 200 AD. These Amerindians were a tribe with highly advanced traditions of agriculture, pottery, weaving, and building. Choiseul is the last known settlement of Amerindians in Saint Lucia, to the extent that their clay pottery craft was passed down through centuries and generations, with mothers teaching the craft to their daughters. Rural communities, such as Choiseul, have an invaluable array of products that represent untapped potential. Maximizing the potential benefits from the natural wealth in its soil and clay will require taking the next steps to gain recognition for quality and establish a solid reputation for its specific clay pottery products in the global community's eyes. A GI for Choiseul pottery is one such tool which can be utilized as leverage to harness the full potential of Choiseul pottery. Choiseul, the undisputed craft capital of Saint Lucia, is well poised to benefit from placing its clay pottery craft on the global stage through the registration of a GI for Choiseul pottery, thereby opening new pathways for trade and the realization of added financial gains for the community.
Page 22. Advertisement. Nichols John and Company. Attorneys at law, notaries royal, and intellectual property agents. Saint Lucia's leading intellectual property service provider. Trademarks, copyrights, geographic indications, industrial designs, oppositions and litigation. Address: Helenora House, True Garnier Financial Center, Point Seraphine. P.O. Box 1209, Castries LC 04101, Saint Lucia, W. I. Call +17584522000/451923 and 7/4517573. Email njandco.ipmanager@gmail.com. www.stlucialayer.com.
Page 23. Profile. Name: Desma Charles. Firm name: Amicus Legal. Position: Senior Associate Attorney. Country: Saint Lucia. Website: www.amicus.legal. Ms. Desma Charles is an attorney at law from Saint Lucia with 20 years of experience at the Saint Lucia Bar. She is presently a senior associate attorney at the law firm Amicus Legal, where she oversees the corporate, commercial and intellectual property (IP) portfolios. Amicus Legal is a dynamic, full-service law firm specializing in a wide variety of practice areas, with an emphasis on business and corporate law, commercial litigation, and conveyancing. Prior to this role, she held the post of Registrar in the Registry of Companies and Intellectual Property of Saint Lucia for nearly 17 years and Deputy Chief Registrar of the Eastern Caribbean Supreme Court, Court of Appeal, for 2.5 years. Desma possesses a Master of Laws degree, LLM, with merit, from the University of London, with specialization in commercial and corporate law. This achievement, coupled with her wealth of knowledge, training, and experience, signifies her passion and expertise in the corporate and IP fields. She also holds a Bachelor of Laws degree, LLB, from the University of the West Indies, Barbados, and a Legal Education Certificate, LEC, from the Hugh Wooding Law School, Trinidad. During her role as registrar, Desma was instrumental in advancing her country's commercial and IP sectors. On the corporate side, she contributed significantly to legal reform and the modernization of the registry's structure and processes. With respect to IP, she made great strides both institutionally and technically by promoting the IP agenda, engaging in raising awareness and outreach programs, and transforming the IP landscape in Saint Lucia. This was achieved with the invaluable assistance of the World Intellectual Property Organization, WIPO, the European Union Intellectual Property Office, EUIPO, under the CAR-IPI project, as well as other IP organizations and offices. It is also worth noting that, throughout her career, she received formal training in IP not only in the foundational and practical aspects but also in more advanced, cross-dimensional areas dealing with the management of IP rights and the commercialization of IP assets. She has also received certification for several courses completed with the WIPO Academy. Desma has proven to be a professional who is efficient and well-equipped to handle corporate and IP matters. She fully appreciates the economic value of IP and endeavors to use her expertise to strengthen the IP portfolio at the firm with which she now works and promote IP in her country, Saint Lucia. Page 24. Article. Disclaimer. Images and references related to this article can only be seen in the print and digital versions of the magazine. Spotlight on Saint Lucia. Nurturing the IP Landscape, The Road to Excellence. Written by Ms. Desma F. Charles, Senior Associate Attorney, Amicus Legal, Saint Lucia. It is an established viewpoint that intellectual property, IP, plays a significant role globally. This perspective is neither different nor diminished in the Caribbean region. IP is proven to contribute not only to economic growth and development but also to foster creativity and innovation in individuals and communities from all walks of life. The Caribbean region has great potential for IP development, particularly in the creative industries, which include music, culinary traditions, and diverse artistic expressions due to its rich cultural heritage. IP's budding prosperity in the Caribbean is gaining prominence in the agricultural, sports, and tourism arenas. Visibility in these sectors increases the potential for the Caribbean's IP framework to soar to excellence. Notwithstanding this anticipated eminence, there is a need for further strengthening of the region's IP laws and enforcement mechanisms to fully capitalize on this potential. Functioning in an IP environment in the Caribbean is unique, and it has both achievements and challenges. The experience in Saint Lucia is no exception. Saint Lucia, an island country in the Windward Islands of the Lesser Antilles in the eastern Caribbean Sea and covering a land area of 617 square kilometers, 238 square miles, with an estimated population of approximately 180,000, boasts 2 Nobel laureates. On the international scale, this is assessed to be the Caribbean country which has produced the most Nobel laureates per capita. The direct correlation between this accomplishment and the overall potential that Saint Lucia possesses is immediately apparent. Saint Lucia's IP framework, comprising both legal and technical, is enabling its potential to flourish. The Orange Economy. The World Intellectual Property Organization, WIPO, has been assisting the Caribbean under the Orange Economy Initiative, a program designed to help the region develop its IP framework to bolster the creative and cultural industries, specifically targeting young people. Recognizing the creative industries as a significant economic driver, WIPO's support of the development of the Caribbean through policy and funding initiatives can also contribute to job creation, socio-economic progress, and fostering innovation. Music. It is no secret that Saint Lucia's vibrant music landscape has been evolving. While the traditional music beats of reggae and calypso are synonymous with the Caribbean, Saint Lucia has broadened its creativity by composing a unique genre called Dennery segment. This genre is a fusion of traditional Caribbean music and modern electronic music, comprising fast-paced, upbeat rhythms with bold and expressive lyrics, usually in the Saint Lucian Creole language. This innovative genre of music is usually the highlight at parties and other social events in and outside Saint Lucia. The country also proudly spotlights Saint Lucian-born Johann Yogi de Turville, the first Saint Lucian to win a Grammy Award for his work on Chris Brown's album 1111, Deluxe. His victory at the 2025 Grammy Awards is a landmark occasion for Saint Lucia and the Caribbean. It is a testimony of the talent and creativity that characterize the region. The potential of IP in the music industry continues to expand, and under the Orange economy, musicians, songwriters, producers, and others have opportunities to benefit from WIPO's development agenda. This agenda is geared at strengthening IP frameworks, providing technical assistance, and building the capacity of artists through national IP channels. Cultural heritage and diverse artistic expressions. The Caribbean portrays a diverse cultural landscape with unique traditions, folklore, and artistic expressions, which make it a rich source of IP potential. Saint Lucia prides itself on its rich cultural heritage, embracing African, French, and English influences as well as influences by indigenous peoples. This cultural blend is deeply intertwined with IP, with many avenues for the protection of creative expression and the potential for leveraging this heritage for economic growth and cultural preservation. This can be attained through sustainable tourism, cultural preservation initiatives, and creative industries, fostering economic growth while safeguarding its unique cultural identity and traditions. National organizations such as the Cultural Development Foundation, CDF, and the Folk Research Center, FRC, play a critical role in safeguarding and licensing this cultural knowledge and expression, ensuring not only fair recognition and compensation for the creators but also preserving its cultural legacy for future generations. Saint Lucia ensures that its cultural heritage lives on in the celebration of activities such as its annual carnival, national flower festivals, the observance of its Creole heritage every October, and its expression of folklore in various art forms. The concepts of traditional knowledge and cultural expression were solidified by the adoption of the WIPO Treaty on Intellectual Property, Genetic Resources, and Associated Traditional Knowledge on May 24, 2024, in Geneva, which was assented to by Saint Lucia. This international agreement aims to, among other things, provide a legal framework for protecting traditional knowledge, which includes practices, skills, and innovations that result from intellectual activity in a traditional context, as well as traditional cultural expressions in the forms of music, dance, art, and designs. The treaty is a significant step in international lawmaking that protects indigenous peoples' knowledge and resources. Saint Lucia hopes to benefit from the treaty when it ratifies it in due course. Emerging IP visibility and budding prosperity. First geographical indication, GI. Saint Lucia is excited to announce its first registered geographical indication, GI, for Saint Lucia rum. Saint Lucia's unique rum distillery, St. Lucia Distillers, is honored to be granted a protected GI for its fine rums, Admiral Rodney, Chairman's Reserve, and Bounty and Denros, recognizing them as the benchmark for rums produced in Saint Lucia and celebrating their deep connection to the island's history and heritage. The unique terroir of Saint Lucia, which encompasses its fertile volcanic soil, tropical climate, and pristine rainwater, imparts a distinct character to Saint Lucia rum, resulting in lifelong generations of craftsmanship and dedication to excellence. On November 25, 2024, this prestigious status was bestowed upon the product through a GI registration by the National Intellectual Property Office, granting the certification that every bottle of Saint Lucia rum is crafted to the highest standards, exclusively on Saint Lucian soil. The GI represents not just a mark of quality but a testament to the craft and passion of Saint Lucian rum making, which will undoubtedly accentuate and preserve the island's rich heritage. agricultural uniqueness and culinary creations. Saint Lucia has something unique to offer in the agricultural and culinary arenas by offering a taste of Saint Lucia. As the name denotes, this brand was developed by the country's national export agency, Export Saint Lucia, to showcase Saint Lucia's talent and uniqueness in the agriculture, food and beverage, and agro-processing industries. More importantly, the brand is a registered trademark in Saint Lucia, currently covering Export Saint Lucia's primary sectors, which feature not just the distinctive words Taste of Saint Lucia, but incorporates a logo symbolizing the highest quality of goods, services, and exports that will be distinguishable all over the world. Women in Entrepreneurship. Helen's Daughters is an Empower Women project based in Saint Lucia that promotes the principles of rural women's economic empowerment. The project was coined Helen's Daughters as the name Helen holds significance in Saint Lucian society, with the island first being called the Helen of the West Indies. Helen's Daughters has embarked on strategic initiatives to educate and monetize the efforts of Saint Lucian women and youth who grow and harvest agricultural produce. The group has pursued trademark registrations in Saint Lucia, which will provide IP protection, brand recognition, economic value, and commercial viability. The IP and Women in Entrepreneurship project is a WIPA-led women's forum which provides a platform for the open exchange of cross-regional experiences to identify challenges and propose solutions and best practices in the use of IP by women entrepreneurs. The forum brought together 19 women entrepreneurs from 9 countries, including Saint Lucia among the 3 selected from the Caribbean, as well as African countries, enabling them to showcase their products to a local and international audience. IP, sport, and tourism. Sports highlight several facets of IP. Whether it is patents, trademarks, brands and designs or copyright and related rights, these rights form the basis of licensing and merchandising agreements that generate revenues to support the development of the sports industry, thereby supporting the global sports ecosystem. Saint Lucia is inspiring the world with a unique sport and tourism medley in the IP landscape. Julian Alfred made history by becoming Saint Lucia's first ever Olympic gold and silver medalist, securing gold in the 100 meters with a new national record of 10.72 seconds and silver in the 200 meters, propelling Saint Lucia into the global spotlight. In a momentous ceremony on September 26, 2024, the Saint Lucia Tourism Authority proudly announced world-renowned athlete Julian Alfred as an official tourism ambassador for Saint Lucia as a preferred destination. This landmark alliance seeks to elevate the island's profile as a premier global travel destination, bringing pride to Saint Lucia and inspiring individuals worldwide to nurture their talents and strive for excellence. Julian's ambassadorship in the tourism arena will bolster her participation in promotional events for Saint Lucia in key markets, including media engagements to promote the island with a mix of key IP components such as the co-branding of the prominent Saint Lucia logo on Julian's Puma competition and warm-up kits. This partnership is expected to enhance the island's visibility by leveraging Julian as a contemporary global ambassador for Saint Lucia, thus promoting the marriage of IP and sport as a prospective economic booster. Overcoming challenges and soaring to excellence. These cross-cutting sectors present a wealth of creativity that can be protected through copyrights, trademarks, and geographical indications, acquiring more importance in individual businesses and national economic prosperity. However, challenges remain for the region. Caribbean countries generally have outdated legislation, weak enforcement systems, understaffed IP offices, and a lack of regional coordination, which hinder innovation and economic growth. To overcome these challenges, Saint Lucia is poised to navigate the uncertainties to ensure that the full IP potential is realized to optimize its economic advantage. Over the last few decades, IP laws in Saint Lucia have undergone significant adjustments to align with international standards and comply with international treaties. The government of Saint Lucia, through the IP Office, has benefited from IP sensitization programs and capacity-building initiatives, enforcement training and technical assistance to strengthen the operations of the office through the support and efforts of WIPO, other regional and international organizations, and IP offices. Saint Lucia recognizes that to thrive and realize its true IP potential, new strategies must be adopted. There is a need for better regional collaboration among Caribbean countries to develop unified laws and enforcement mechanisms through unions like the Caribbean Community, CARICOM. This will entail legislative reform to update and harmonize IP laws to comply with international standards and best practices. With the continued assistance of organizations like WIPO, Saint Lucia can pursue stronger public awareness campaigns to educate the public about the importance of IP protection and capacity-building activities for IP officials to increase their knowledge, skill, and expertise. Further strategies that will accelerate Saint Lucia's progress to IP excellence include investment in and the adoption of enhanced digital platforms for IP registration and online access to information, strengthening border controls, and enhancing its legal framework and investigative capacity to deter IP infringement. Lastly, and to complement the IP system, the country is striving to advance programs and initiatives to encourage entrepreneurship and the commercialization of IP, particularly among the youth. Saint Lucia will remain focused on the pursuit of growing the IP economy and advancing on the road to prosperity and excellence.
Page 29. Advertisement. The IP Tech and Innovation Services Annual. Spotlighting the game changers delivering innovation and support across the IP industry. Launching at IP Service World, Munich, Germany, 24 to 25 November 2025. Info at northonsprmarketing.com. +44 0 2038130457. www.iptechnovation.com.
Page 30. Advertisement. PatWorld. Global IP Research Services and Training. PatWorld Resurrect Services. Trusted, reliable, accurate. The PatWorld team combines scientific expertise with commercial insights to deliver comprehensive IP research solutions. Our services. Partner with a team trusted by tech companies, universities, and IP professionals worldwide. PatWorld Database, your ultimate AI-powered patent research tool. PatWorld Training Course CPD, certified online learning. Get in touch. Phone +440 1633 816601. Email mail@patworld.com. www.patworld.com. Innovation House, 6 Cedar Court, Celtic Springs, Newport NP 108FY.
Cayman Islands. Page 31. Profile. Name, Mrinali Menon. Law firm, HSM IP Limited. Position, Senior Intellectual Property Manager. Country, Cayman Islands. Website, www.hsmoffice.com. Mrinali Menon is a Senior Intellectual Property Manager at HSM IP Limited. In the Cayman Islands. Mrinali is a proficient legal practitioner specializing in intellectual property and technology laws. She oversees a team of IP specialists and has extensive experience in managing patent, trademark, and copyright portfolios for a diverse range of brand owners worldwide, including the Caribbean, Central, and South America region. Mrinali has a deep understanding of IP rights and assists clients in providing strategic advice on portfolio management, enforcement, and development. Her outstanding work has earned her a ranking as a leading associate in the Legal 500 Cross-Caribbean Expertise 2025 Guide. Mrinali has a dual degree in law, including a master's degree in law, LLM, from Columbia Law School, New York, and a bachelor's degree in law, BA, LLB, from Symbiosis Law School, India. She was also a part-time instructor at Columbia University, New York, where she taught IP and technology law. Prior to joining HSM IP, Mrinali worked in the United States, New York, and India. She brings rich experience in managing both contentious and non-contentious IP matters, including trademarks, copyrights, patents, designs, and more. Her expertise spans across prosecution and dispute resolution, including advising clients on complex transactional and corporate issues related to IP acquisition and licensing. Additionally, she is well versed in areas such as commercial technology agreements, data protection, privacy and security concerns, digital assets, open source software, and other critical IP matters. In her previous roles, she represented brand owners in IP infringement cases before the Supreme Court and High Court, managed high-value commercial transactions, and successfully negotiated and finalized deals in both New York and India. Mrinali currently serves as a member of the International Trademark Association's INTA Brand Restrictions Committee and Outreach Subcommittee for the 2024 to 2025 term. The committee informs policymakers about the important role of trademarks in the economy and society, and the need for balanced regulations that address public health concerns while respecting private property rights. Page 32. Article. Disclaimer: images and references related to this article can only be seen in the print and digital versions of the magazine. From Code to Creation. RE's growing influence on law and intellectual property in the Caribbean. Written by Mrinali Menon, Senior Intellectual Property Manager at HSM IP Limited, Cayman Islands. Artificial intelligence, AI, is no longer the new kid on the block. It continues to significantly transform various industries worldwide, including the legal sector. The Caribbean jurisdictions, too, are keeping pace with these advancements and are not far behind in adopting AI-driven changes. As AI becomes the new normal in our lives, it is reshaping traditional processes, particularly in the world of innovation and intellectual property, IP, as well as bringing in several legal and regulatory implications demanding attention. This article seeks to examine the current AI advancements in the Caribbean, exploring the progress made so far and the challenges that remain. AI and IP: where is the intersection? As AI drives innovation, many AI platforms, such as ChatGPT, Azure, DALL-E, etc., are built upon large language models, LLMs, developed through extensive training on huge datasets powered by machine learning. These LLMs process megabytes of data gathered from the internet and other sources to train the software to understand human language and mirror human-like behavior, including generating innovative results in response to images, code, songs, etc. This raises two critical questions. Who owns this generative IP, and what differentiates an AI-generated work from one created by humans inputting data into the platform? Under the regular IP laws, authorship belongs to a human, but in this generative era, the question of ownership becomes complex. With innovation comes new challenges, and these challenges highlight the need to review existing practices. Who owns the IP rights if the AI creates the work? Are there any existing laws that extend protection to technology-generated works? What are the current challenges? The current landscape of AI-specific legislation and developments in the Caribbean. The United Nations Educational, Scientific and Cultural Organization, UNESCO, introduced the Caribbean AI Policy Roadmap in November 2024, focusing on the Small Island Developing States, SIDS. Per the research, UNESCO identified 4 pillars: culture and creativity, governance and transformation, education and upskilling, and resiliency and sustainability, and recommended focusing on these pillars for progression. Each pillar is a cornerstone of a growing economy, with post-pandemic economies increasingly focusing on technology and digitalization. Several Caribbean jurisdictions are making significant strides to keep pace with these global advancements. A review of the 2023 Government AI Readiness Index issued by the UN Economic Commission for Latin America and the Caribbean, ICLAC, highlights the consistent advancements made by the Dominican Republic, the Bahamas, Jamaica, Barbados, Trinidad and Tobago, Antigua and Barbuda, and St. Kitts and Nevis toward shrinking the gap between the technological changes and the government reforms. The Dominican Republic was one of the first Caribbean countries to introduce the Estrategia Nacional de Inteligencia Artificial in 2020, followed by Jamaica, in February 2025, publishing the National AI Task Force Report. Jamaica's Task Force Report 2 comprises interesting recommendations towards the potential use of AI, shadowing the government's commitment to digital transformation. A notable suggestion is the initiative to create interim guidelines for regulating AI, ethics, data privacy, and establish a dedicated national AI regulatory authority overseeing advancements for ethical, transparent development. Furthermore, jurisdictions such as Cuba, Trinidad, Belize, Dominica, Suriname, St. Martin, and St. Vincent are focusing on empowering their digital economies to remain competitive on the global stage, at par with the swift advancements in the European Union's AI Act and AI-focused legislations in the United States. Despite these discussions, the Caribbean awaits a jurisdiction to formally enact or incorporate AI-friendly changes to its existing IP laws. Although many economies are experiencing growth with a rise in technology-driven companies, jurisdictions are yet to invest fully in their legislative frameworks. Who owns the IP rights if the AI platform creates the work? Currently, the majority of copyright legislation defines an author as an individual domiciled or resident of a specific jurisdiction or a company incorporated in a country. Reference to a person is not defined. Hence, the question of whether any artistic work generated through AI software can be deemed to be an author continues to be actively debated under the law. The United Kingdom, the European Union, and especially the United States are exploring various interpretations to tackle these issues. In fact, these jurisdictions have also noticed a sudden increase in lawsuits against generative AI companies alleging copyright infringement. Earlier this year, the United States Patent and Trademark Office, USPTO, welcomed its first AI-generated copyright registration. This registration was granted for the selection, coordination, and arrangement of elements otherwise generated through AI software. Interestingly, this application was previously rejected, citing that the work lacked human authorship necessary to support a copyright claim. Subsequently, the author was directed to provide a step-by-step analysis, leading to its registration. Even though courts are yet to render a decision on the ownership questions, such developments tend to inspire IP offices globally, including those in the Caribbean, to explore the possibility of registering similar creative works. As for now, there are no jurisdictions in the Caribbean that have reported cases concerning the involvement of AI in creating IP. Many jurisdictions are still leaning towards understanding the full extent of the impact of technology and are still exploring the legislation protecting works created by the computer or work created by AI software. Antigua and Barbuda are considering adopting an approach similar to the laws accepted in the European Union's Artificial Intelligence Act. Similarly, Guyana and Puerto Rico are presently working towards introducing AI-specific legislation to condemn misuse of AI-based platforms. Are there any existing laws that extend protection to technology-generated works? Currently, none in the Caribbean. The Caribbean Court of Justice, CCJ, and the Caribbean Agency for Justice Solutions, CAJS, have collaborated to incorporate AI in transforming justice through two AI-based tools called AIDA and Judy. While the former assists in facilitating legal research, the latter assists in automating the creation of court documents. Both these tools have been delivering successful results, enabling judicial efficiency. This vision of AI in legal justice was further bolstered with the CCJ issuing Practice Directions No. 1 of 2025 on the use of generative artificial intelligence tools in court proceedings 3 recently. It is interesting to see CCJ providing guidance for generative AI use for different users, including allowing attorneys and legal practitioners to draft submissions, summarize legal arguments, and conduct legal research while ensuring they thoroughly fact-check and review for accuracy to comply with legal standards. The CCJ has gone a step further by stating that the court may impose costs and rejection orders if any party fails to adhere to the practice directions. It is undoubtedly a strong and much-needed directive, especially with the increasing use of AI within the legal sector. Staying abreast of the many instances of legal misinterpretations and errors being observed, the Grand Court of the Cayman Islands Civil Division recently handed down a judgment in Bradley and Chuang v. Linda Freichakin, 2025, CIGC, Civilian, 5 discussing the need for counsel and the legal industry to pay more attention to submissions prepared by deploying the use of AI. This case witnessed the defendant's memorandum filled with erroneous material and several hallucinations that did not assist the court and, in fact, risked leading it astray. Justice Jalil Asif KC, in his judgment, emphasized the need for attorneys using AI to be vigilant to the potential errors and hallucinations generated by technology. While attorneys must always uphold ethical standards, this decision is welcoming as the Grand Court recognizes the use of technology to make legal disputes more efficient and expedite resolution. A similar issue addressing AI errors was first decided in June 2023 when Judge Kevin Castell in the Southern District of New York sanctioned 2 attorneys for submitting a brief drafted by ChatGPT containing references to hallucinated case law authorities. The judge similarly mentioned that there is nothing inherently improper about using a reliable artificial intelligence tool for assistance, but found that the attorneys were not compliant with their legal and professional responsibilities by submitting legal documents without fact-checking. Situations like these highlight the extent to which AI and related technologies have integrated into our daily lives, including our profession. While technology can enhance efficiency, it is ultimately crucial to ensure that the human author acts reasonably while using the technology. What are the current challenges and areas needing attention? The future of AI and IP in the Caribbean is promising and bright. With regional cooperation and advancements continuing to evolve rapidly, the Caribbean is steadily progressing to stay competitive while ensuring businesses, innovators, and creators are equipped to protect their IP creations. The 2024 ICLAC Meeting 4 identified the key challenges hindering digital transformation as organizational and cultural barriers, data technology barriers, and human resource capacity. However, with the incoming policies underway in various jurisdictions, the Caribbean is taking on the challenges and capitalizing on the emerging opportunities with the growing influx of technology and technology-backed companies in IP. Ultimately, the need of the hour is for jurisdictions to adopt laws aiming towards AI infrastructure and advancements. There also needs to be a higher impetus towards investing in AI-backed workforce, policies, and legislation to train and increase awareness. AI is here to stay, and it is in the best interest of each economy to adapt both administratively and legislatively to stay competitive. The time to evolve is here and now.
Page 35. Advertisement. Northon's Media PR and Marketing Ltd. IP 360 Hub. The Global Industry Guide connecting the global IP community. IP 360 Hub, Handbook 2026. IP 360 Hub connects IP professionals, law firms, and service providers through an affordable print and digital platform. Expand your network and visibility. Professionals, counsel, service providers, advisors, industry partners. www.ip360hub.com. info@northonsprmarketing.com. +44 0 2038130457.
Trinidad and Tobago. Page 36. Profile. Name, Terita Kallu, LLM, LEC, LLB. Law firm, Terita Kallu Law. Position, intellectual property attorney at law. Country, Trinidad and Tobago. Website, www.teritakallu.com. Professional biography. Terita Kallu is an intellectual property attorney at law based in Port of Spain, Trinidad and Tobago, with over 12 years of legal practice. Through her practice, Terita Kallu Law, she specializes in IP protection, management, litigation, and enforcement. She has partnered with Intellect Management Services, a Barbadian company with 20 years of experience in the IP field, to provide comprehensive IP management services across the Caribbean region, including IP valuations, audits, and due diligence. Terita Kallu Law represents international law firms, companies, and individuals worldwide for all IP-related services throughout the Caribbean region. As part of her commitment to IP education and accessibility, Terita hosts a monthly pro bono IP clinic, offering guidance on IP issues to those who might not otherwise have access to such specialized legal expertise. Education and certifications. Terita's academic credentials include Bachelor of Laws degree from the University of the West Indies, Legal Education Certificate from Hugh Wooding Law School, Master's degree in Intellectual Property Law and Management from the University of Strasbourg, France. Currently pursuing PhD research in IP management at the University of Strasbourg, France. She is a WIPO certified trainer at the National Intellectual Property Training Center of Trinidad and Tobago and serves as a certificate lecturer for the EPOCP Master's Program in IP Management. Leadership positions and professional memberships. Terita is a co-chair of the International Affairs Committee of the International Institute of IP Management. She is also a director of the Innovation Association in Trinidad and Tobago, a member of the Intellectual Property Committee of the Law Association of Trinidad and Tobago, and has recently joined the Fashion Law Committee of ASIPI, Inter-American Association for Intellectual Property. Terita Kalu Law maintains active memberships in several professional IP organizations. INTA, International Trademark Association. IPCA, Intellectual Property Caribbean Association. ASIPI, Inter-American Association for Intellectual Property. I3PM, International Institute of IP Management. Professional experience. Terita's diverse experience spans both public and private sectors. Public sector. At the Intellectual Property Office of Trinidad and Tobago, she served as a legal counsel. She conducted trademark examinations and worked on the implementation of various IP laws, including the recently adopted Trademarks Regulations, 2020. Private sector. Her boutique legal practice focuses on corporate and commercial law with a specific emphasis on intellectual property law. Publications and international reach. Terita authored the Trinidad and Tobago chapter of the Manual of Industrial Property, also known as the Brown Book, published by Wolters Kluwer and recognized as an international leading authority for IP practitioners worldwide. In 2024, through the International Affairs Committee of I3PM, Terita launched a monthly international newsletter, I3PM Worldview, which focuses on international IP management developments. Page 37. Article. Disclaimer. Images and references related to this article can only be seen in the print and digital versions of the magazine. Building an IP ecosystem. Lessons from Trinidad and Tobago. Terita Kalu, LLM, LEC, LLB, Attorney at Law at Terita Kalu Law, Trinidad and Tobago. Trinidad and Tobago is globally recognized for its vibrant culture, with its famous carnival and rich musical traditions, such as calypso and soca. What remains less recognized internationally is how the nation has been quietly transforming into a regional powerhouse for intellectual property innovation and protection. This evolution reflects deliberate strategies, forward-thinking policies, and growing recognition that IP assets are central to economic diversification and sustainable development. Despite its modest geographical footprint, Trinidad and Tobago has achieved prosperity primarily through its oil and gas industry. The nation's wealth has fostered a high-income economy that actively cultivates both entrepreneurial ventures and innovative initiatives. This is supported by an advanced IP system. While local use primarily focuses on trademark registrations, international corporations ensure comprehensive protection of their trademarks and patents in this country, recognizing its position as a regional economic powerhouse. From an enforcement perspective, the country's strategic importance as a regional shipping hub makes it particularly valuable for global brands. This strategic position motivates major companies worldwide to secure and enforce their IP rights within Trinidad and Tobago. Early lessons learnt. Trinidad and Tobago's IP journey has not been without significant missteps, particularly regarding one of its most iconic cultural innovations, the steel pan. Despite being the birthplace of this revolutionary musical instrument, which transformed discarded oil drums into melodic percussion, the country failed to secure adequate IP protection for the steel pan technology and innovations, and thus failed to benefit from its exploitation. This oversight became painfully apparent during the G-pan dispute, where improved steel pan designs developed with significant government funding faced challenges in patent protection and commercialization. The situation was further complicated by a series of patent disputes, in which foreign inventors secured international patents for steel pan-related innovations while local creators remained unprotected. Several American and European inventors obtained patents for manufacturing techniques, tuning methods, and design improvements that built directly upon Trinidadian innovations. These foreign patents effectively allowed external entities to profit commercially from generations of local knowledge and craftsmanship, while local pan pioneers received minimal recognition or financial benefit. In response to these lessons, Trinidad and Tobago has recently made significant strides to protect the steel pan as part of its national heritage. Notably, the country has pursued protection of the steel pan as a geographical indication, GI. This GI designation aims to ensure that authentic steel pans are recognized as originating specifically from Trinidad and Tobago, providing legal protection against misappropriation and misuse. The initiative not only preserves the cultural integrity of the instrument but also creates economic opportunities for local craftspeople by establishing a clear connection between the product and its place of origin. These experiences revealed fundamental gaps in the country's approach to IP protection, particularly for cultural and creative assets that form part of the nation's identity. They demonstrated the critical importance of protecting indigenous innovations and served as a catalyst for Trinidad and Tobago's more comprehensive approach to IP protection. The painful lesson, that innovation without protection leads to exploitation rather than economic benefit, has no doubt profoundly shaped the nation's current IP strategies. IP landscape in Trinidad and Tobago. Trinidad and Tobago is a signatory to major international IP conventions, including the Paris Convention, the Berne Convention, and the Agreement on Trade-Related Aspects of Intellectual Property Rights, TRIPS. It has also endeavored to meet international standards, as evidenced by the adoption of the Rome Convention for the Protection of Performers, Producers of Phonograms, and Broadcasting Organizations, the Marrakesh Treaty to facilitate access to published works for persons who are blind, visually impaired, or otherwise print-disabled, and the Beijing Treaty on Audiovisual Performances. This international engagement has positioned it as a global player in IP protection while providing a framework for local innovation. The nation has developed its own unique approach, blending international standards with local cultural and economic realities. Trinidad and Tobago has continuously updated the suite of legislation governing IP rights. The most recent and notable update to its IP system was the introduction of a new Trademarks Act, which enabled a wider scope of registrable marks, including non-traditional trademarks, improved enforcement procedures, and strengthened the rights of trademark owners and licensees. The ease of IP protection has been enhanced through the adoption of the Madrid System for International Trademark Registration and the Patent Cooperation Treaty. Significant steps are also being taken toward adopting the Design Law Treaty and acceding to the Hague Agreement concerning the international registration of industrial designs. Additionally, the introduction of an electronic filing system has significantly improved efficiency, offering a faster and more convenient process. This digital innovation simplifies application procedures for both domestic and international applicants, allowing for the electronic submission of applications and supporting documentation. Trinidad and Tobago has made significant strides in developing a comprehensive IP ecosystem. While implementing modern IP laws remains a priority, authorities have recognized that a holistic approach is essential for effective protection and commercialization of IP rights. Customs enforcement has intensified, resulting in increased seizures of counterfeit goods. This act stems from several key developments, such as updated trademark legislation, the creation of specialized task forces, including the Multi-Agency Task Force and Anti-Illicit Task Force in Trinidad and Tobago, and valuable private sector collaboration. Public awareness has also received considerable attention through educational campaigns and the establishment of a national IP training center. Furthermore, extensive training programs have equipped both private and public IP practitioners with the necessary expertise to strengthen the country's IP ecosystem. IP collateralization, unlocking the value of intangible assets. Trinidad and Tobago has developed IP valuation guidelines and a collateralization framework, which represents a transformative advancement for the nation's IP ecosystem. It aims to address one of the most significant barriers to innovation financing in developing economies. The introduction of specialized training for legal and financial professionals helps implement this framework effectively across sectors, creating an interconnected ecosystem where IP assets can be leveraged for financial success. The systematic approach to IP valuation and collateralization directly aims to address the asset paradox that has historically limited growth in creative sectors, where businesses possess valuable intangible assets but cannot convert them into financial capital. By incorporating IP assets into the mainstream financial system, Trinidad and Tobago can effectively build an innovation ecosystem where creative output is recognized not just for its cultural value, but as a genuine driver of economic development and business growth. Strategy at its core. Trinidad and Tobago's IP development has been guided by its national IP strategy. While only formally adopted by Cabinet in 2023, the measures outlined in the strategy have been implemented over time. The strategic measures include strengthening the administration of IP, encouraging the commercialization of IPR, promoting the cultivation of an IP culture, improving IP law enforcement, increasing the capacity to create IP, developing intermediary services for IPRs, developing IP human resources, and expanding international exchanges and cooperation in IP. The country has strengthened its core approach by developing specialized sector-specific strategies that safeguard its unique cultural heritage. Recent initiatives include a customized IP strategy for the Carnival Museum of Trinidad and Tobago and an upcoming Global First, a dedicated IP strategy for sports. The Carnival IP Museum strategy aims to document, preserve, and monetize the rich IP associated with this cultural phenomenon. The strategy involves cataloging designs, music, choreography, and other creative elements of Carnival, ensuring proper attribution and protection. It also aims to implement educational programs to raise awareness about the IP aspects of Carnival arts. This innovative approach demonstrates how IP protection can be applied to traditional cultural expressions, creating economic opportunities while preserving cultural authenticity. The strategy serves as a model for other nations with rich cultural traditions seeking to balance preservation with commercialization. Trinidad and Tobago has produced world-class athletes in various sports, from cricket to track and field. The country's attempt to implement an IP and sports strategy can help to capitalize on this sporting heritage by protecting and monetizing sports-related IP. The strategy would likely address various aspects of sports IP, including athletes' image rights, team branding, event broadcasting rights, and sports innovations. Challenges and future directions. Despite IP achievements, challenges persist. Enforcement efforts suffer from resource limitations, and collaboration from IP owners is lacking. IP education remains a challenge as many businesses still lack awareness of its economic value. Furthermore, while the IP Office has implemented solutions, such as the MOU with Chile's IP Office, which provides affordable international search reports for patent filings, protection costs still create significant barriers to protection for local inventors. Looking ahead, the future of IP in Trinidad and Tobago appears promising, nonetheless. The country is investing in IP education at various levels, from schools to professional training programs. The growing focus on IP valuation and commercialization can also help rights holders to maximize the economic potential of their intellectual assets. The government's National Development Strategy, Vision 2030, explicitly recognizes the role of IP in building a knowledge-based economy. This high-level commitment suggests that IP will continue to receive policy attention and resources in the coming years. Conclusion: a model for small nation IP development. Trinidad and Tobago's missteps as well as its approach to IP development offer valuable lessons for other small nations, particularly in the developing world. By combining international standards with locally relevant initiatives, the country has created an IP ecosystem that aims to support innovation while protecting cultural heritage. The sector-specific strategies show a more structured approach where strategies are tailored to different contexts rather than applied uniformly. Similarly, the focus on IP financing through collateralization shows how IP can be integrated into broader economic development strategies. As Trinidad and Tobago continues its IP journey, continued investment in legal infrastructure, education, and enforcement is required to leverage IP as a driver of economic growth and cultural preservation. For international businesses and creators, Trinidad and Tobago offer not just a robust IP ecosystem but also a model for how small nations can punch above their weight in the global knowledge economy. The country's experience shows that size is no barrier to IP development. Vision, strategy, and commitment are what truly matter.
Page 40. Advertisement. Abdul Razak and Associés. Your IP experts in Haiti. 19 Rue Moïse, Pétionville, Haiti. Telephone 509-3819-9200. Email vanessa@cabinetabdulrazak.com.
Haiti. Page 41. Profile. Name: Vanessa Abdelrazak. Law firm, Abdelrazak and Associates. Position, founder partner. Country, Haiti. Website, www.cabinetabdelrazak.com. Vanessa Abdelrazak is an attorney registered with the Port-au-Prince Bar with over 15 years of experience advising and representing clients in Haiti and internationally. She is a trusted advocate for businesses, creators, and innovators, helping them protect and enforce their IP rights in an increasingly complex legal landscape. Her expertise in IP law spans trademark registration, copyright protection, patent filings, industrial designs, and brand enforcement. Vanessa has guided numerous companies, ranging from startups to multinational corporations, in securing and defending their IP assets in Haiti, ensuring compliance with local regulations. Her firm, Abdelrazak and Associates, is recognized for its strategic, client-centric approach, assisting businesses in navigating the registration, protection, and commercialization of their IP. In addition to its client services, Abdelrazak and Associates engages in pro bono work aimed at helping young entrepreneurs and innovators by providing legal guidance on IP protection, business formation, and regulatory compliance. This initiative reflects Vanessa's dedication to fostering innovation and supporting emerging businesses in Haiti. She is a member of various global and regional IP-focused organizations, actively participating in global discussions on emerging IP challenges. Vanessa holds a law degree from Quisqueya University in Haiti and a master's in international and comparative environmental law from the University of Limoges, France. She also earned a master's in public law and a university diploma in comparative legal studies from Aix-Marseille University, France. Additionally, she obtained a diploma of advanced studies in international business law from the University of London and has pursued specialized training in trademark, copyright, and IP enforcement through programs with the World Intellectual Property Organization, WIPO. Her commitment to continuous learning is reflected in her participation in international IP conferences, legal training programs, and policy discussions. Vanessa regularly engages with global industry leaders, regulatory bodies, and businesses to stay ahead of emerging trends, enforcement strategies, and digital brand protection. Beyond her legal practice, Vanessa is dedicated to mentoring and educating the next generation of lawyers. Since 2016, she has been a lecturer in environmental and contracts law at Quisqueya University and frequently speaks on IP rights in business and innovation forums. A multilingual professional fluent in French, English, Spanish, and Haitian Creole, Vanessa seamlessly supports international clients looking to expand and protect their brands in Haiti. She is passionate about bridging the gap between IP law and business strategy, ensuring that her clients not only safeguard their rights but also leverage their IP assets for growth and innovation. Outside of work, Vanessa enjoys sports, outdoor activities, music, and reading. She is also actively involved in charitable initiatives, with a strong commitment to education and youth empowerment, values that reflect her deep-rooted sense of service and advocacy. She stands on the executive boards of various organizations in Haiti and the Chamber of Commerce, contributing her expertise to foster economic and legal development. Page 42. Article. Disclaimer: images and references related to this article can only be seen in the print and digital versions of the magazine. The impact of copyright on cultural production in Haiti, legal framework, opportunities, and global potential. Written by Vanessa Abdelrazak, founder and partner at Abdelrazak and Associates, Haiti. Haiti possesses a remarkably rich cultural heritage, defined by its dynamic traditions of music, literature, visual arts, and performance. Its creative output, ranging from the globally recognized rhythms of compa and rara to the internationally celebrated works of Haitian painters and novelists, has shaped cultural discourse in the Caribbean and beyond. Haiti's creative industries represent not only a pillar of national identity but also a sector of substantial economic potential. However, despite this vibrant artistic legacy, Haiti's cultural sector continues to face significant challenges related to the protection of intellectual property rights, IPRs. Although copyright laws exist, enforcement mechanisms remain underdeveloped and inconsistent. Many Haitian creators remain vulnerable to piracy, unauthorized exploitation, and commercial misappropriation of their works. Strengthening the country's copyright regime, legally, institutionally, and digitally, offers a transformative opportunity. Doing so would facilitate sustainable economic development, expand Haiti's international cultural footprint, and empower a new generation of Haitian creators and cultural entrepreneurs. This article explores the impact of copyright on cultural production in Haiti by examining its current legal framework, highlighting success stories in music, literature, and visual arts, and outlining key legal and technological opportunities to support the creative sector. Copyright as a legal and economic instrument. Copyright is more than a mechanism for protecting creators, it is a critical tool for economic empowerment, cultural sovereignty, and innovation. In a global digital landscape where artistic works can be instantly reproduced and disseminated, robust copyright protection ensures that authors, musicians, and artists retain control over their intellectual outputs and are fairly compensated for their creative labor. For a country like Haiti, rich in cultural assets but constrained by institutional fragility, a stronger copyright system could generate local and international revenue for artists and creative industries, attract foreign direct investment in the cultural economy, provide legal infrastructure for emerging creators to monetize their work, safeguard Haitian heritage from cultural appropriation or unauthorized global use. A modern copyright system, aligned with both international norms and the realities of the digital marketplace, is essential to ensuring that Haitian culture is not only celebrated but also protected and sustainably commercialized. Haiti's copyright framework, foundations and gaps. Haiti has already taken significant steps toward establishing a legal foundation for copyright protection. The October 12, 2005, Decree on Copyright in Haiti, as published in Le Moniteur, represents a significant milestone in the evolution of intellectual property law in Haiti, modernizing and expanding the legal protection of intellectual works. The decree reflects a clear intention to align Haitian law with international conventions such as the Berne Convention and the Universal Copyright Convention, Geneva, incorporating contemporary standards in intellectual property protection. It repeals the previous 1968 decree and broadens the scope of protected creations, accounting for digital realities and modern works, including software, databases, and audiovisual content. The decree protects two major categories of rights: economic rights, patrimonial rights. These include the right to economically exploit the work, reproduction, representation, distribution, adaptation. Moral rights. These are inalienable and relate to the author's paternity and the integrity of the work. These rights are recognized from the moment of the work's creation without any requirement for formal registration or deposit. Scope of protection. The text affirms that any original work in the literary, scientific, or artistic fields is protected. This includes translations, adaptations, databases, derivative works, and expressions of folklore. However, it excludes official texts, laws, judicial decisions, and daily news reports. Duration of protection. Literary and artistic works, 50 years after the death of the author. Phonograms and performances, 50 years from the date of fixation or first publication. Broadcasts, 25 years from the date of transmission. Assignment of rights and licensing agreements. The decree strictly governs assignment and licensing contracts. Economic rights may be transferred or licensed, exclusively or non-exclusively. Moral rights cannot be transferred during the author's lifetime, but they can be passed on to heirs. Contracts must be in writing and specify the scope, duration, and terms of use. Neighboring rights. A major innovation is the introduction of neighboring, related, rights, granted to performing artists and interpreters, phonogram producers, broadcasting organizations. These rights authorize or prohibit the use of performances and allow beneficiaries to receive fair compensation, particularly in cases of public broadcast or private copying. Collective management. The decree calls for the creation of a public collective rights management organization, which would defend the rights of authors and holders of neighboring rights. This body is also empowered to enter into international agreements to represent Haitian creators abroad. Sanctions and anti-piracy measures. The decree provides a legal framework for civil and criminal sanctions against infringement, including seizure of unauthorized copies, monetary and penal sanctions, prohibition of devices that circumvent digital rights management (DRM) protections, territorial and international scope. The law applies to Haitian nationals or residents. Works first published in Haiti. Works protected under international conventions of which Haiti is a party. Special provisions for folklore. The decree includes specific provisions for the protection of Haitian folklore. The use of folkloric expressions is subject to authorization by the collective management body, and part of the collected royalties must be allocated to the communities that preserve this cultural heritage. The 2005 decree constitutes a modern legal framework in line with international standards. It provides a solid basis for the promotion and protection of Haiti's cultural sector, provided its implementation is effectively enforced, strong institutions, creator education, public awareness, supported by public policies that promote creative industries, funding, legal training, promotion, adapted to digital realities, especially regarding digital rights management and protection against online piracy. Despite these advances, enforcement remains limited due to resource constraints, limited legal awareness, and infrastructural challenges. Courts lack IP specialization, enforcement agencies are undertrained in copyright issues, and digital piracy remains largely unaddressed. Nonetheless, promising opportunities exist to modernize Haiti's IP regime. Digital platforms are enabling new revenue models for creators. International cooperation could strengthen institutional capacity. Educational initiatives can equip creators with legal literacy and business acumen for global markets. The core legal structures are present. What remains is to operationalize and enforce them to unlock their full potential. However, issues of art piracy, unauthorized reproduction, and cultural appropriation are increasingly common. Stronger copyright enforcement would protect these artists' legacies and secure the integrity of Haitian cultural exports. Legal and technological opportunities. Haiti's creative economy stands at a promising intersection of law and technology. The rise of streaming platforms, digital marketplaces, and remote production tools is reshaping how Haitian creators can produce, market, and protect their work. Digital audio workstations, DAWs, have democratized music production, enabling even resource-limited artists to generate high-quality compositions. Platforms such as TikTok, Instagram, and YouTube have revolutionized discovery and fan engagement, often launching careers without traditional gatekeepers. Artificial intelligence is opening new frontiers in music composition, voice synthesis, and visual art generation. E-commerce and NFTs, non-fungible tokens, now provide artists with innovative ways to commercialize their work and ensure provenance. To harness these opportunities, Haiti must align its copyright law with international digital standards, invest in IP literacy for creators, and establish efficient royalty and licensing systems that are adapted to online platforms. Toward a creative and copyright-enabled renaissance. Haiti's extraordinary artistic and cultural landscape is one of its most valuable national resources. While systemic challenges persist in copyright enforcement, the opportunities for growth, economic, legal, and technological, are immense. Strengthening Haiti's copyright regime is not merely a legal obligation, it is a strategic imperative for cultural preservation, economic development, and global influence. With the right reforms, investments, and education, Haiti can position itself as a cultural powerhouse, offering the world a model of how creativity and legal protection can coexist to empower people, preserve identity, and generate prosperity. A creative renaissance is within reach. The law must rise to meet it.
Page 44. Advertisement. Danny Williams & Co., established Grenadian law firm. Danny Williams & Co., attorneys at law, notaries public and trademark agents. Our services include intellectual property, corporate law, civil law litigation, probate and administration of estate, matrimonial matters and family law, conveyancing and property law and immigration law. Contact us for more info. Telephone +1 473 440 3107. Email info@dannywilliamsandco.com. Lucas Street, St. George's, Grenada. www.dannywilliamsandco.com.
Grenada. Page 45. Profile. Name, Daniela C. Williams Mitchell. Position, Attorney at Law. Law firm, Danny Williams and Company. Country, Grenada. Website, www.dannywilliamsandco.com. Daniela C. Williams Mitchell has been practicing law for more than 20 years at the law firm of Danny Williams and Company in Grenada. The firm's focus areas are corporate and business law, immigration and investment law, real estate and property law, probate and administration, estate planning and intellectual property law. Daniela graduated with honors from the law faculty of the University of the West Indies in 1998 and from Hugh Wooding Law School in 2000. Her education also includes a Master of Laws degree in intellectual property law from the Benjamin Cardozo School of Law at Yeshiva University in New York, USA. Danny Williams and Company is one of Grenada's oldest leading law firms. It was conceived by Daniela's father, Sir Daniel, Danny C. Williams GCMG, KC, who was called to the bar as a barrister in 1968. In 2004, Daniela assumed her role as head of the law firm Danny Williams and Company from her father, Sir Daniel, who is now retired. Danny Williams and Company remains a solution-oriented, full-service law firm, serving clients from all walks of life in all areas of the law. The firm's practice areas include all areas of civil law and litigation, including real estate and property law, probate and administration, estate planning, corporate and business law, family, labor and employment law, investment, citizenship and immigration law and IP law. Daniela is a multifaceted attorney at law. In addition to being a general practitioner of civil law, she has a keen interest in IP law and the reform of copyright, patent and trademark law in Grenada. While pursuing her master's degree in New York, Daniela interned at the New York office of the World Intellectual Property Organization, WIPO, which spawned her interest in and knowledge of international IP issues. The firm's IP work includes giving legal opinions on IP and IP-related issues, filing trademark registrations, renewals, assignments, oppositions, and any other filings as required under the Trademark Act of Grenada. Daniela works with a network of attorneys in the Caribbean and, therefore, can provide referrals to assist with legal issues outside the jurisdiction of Grenada. Daniela was twice awarded scholarships from the International Bar Association, IBA, to attend their law conference in Mexico and South Africa as a delegate. She is a member of the Grenada Bar Association, the OECS Bar Association, the Intellectual Property Caribbean Association, IPCA, and the International Trademark Association, INTA. Daniela has volunteered to lecture in business law and IP law for various interest groups. In her personal life, Daniela supports and serves on various charities in Grenada. She has served and continues to serve on several committees and boards to continue the development of Grenada, both in aspects of law and otherwise. Daniela and her team at Danny Williams and Company are able, competent, knowledgeable, and experienced to assist with all your IP and other legal issues or queries in Grenada. Page 46. Article. Disclaimer: images and references related to this article can only be seen in the print and digital versions of the magazine. Grenada's IP Evolution: Protecting Innovation in the Spice Isle. Written by Daniela C. Williams Mitchell, Attorney at Law at Danny Williams & Co., Grenada. Grenada, known as the Spice Isle, is globally recognized for its spices and stunning landscapes. Our tri-island state is comprised of Grenada, Carriacou, and Petite Martinique. Grenada, as the biggest of the three islands, has a landmass of approximately 120 square miles, while Carriacou spans only 13 square miles, and Petite Martinique, a tiny 0.8 square mile island. Though a small island nation in the Caribbean, Grenada has worked diligently to modernize its legal systems to align with the global economy. Among these efforts, intellectual property, IP, protection, specifically trademarks and patents, has emerged as a cornerstone for fostering innovation and economic growth. These laws safeguard creators and businesses, ensuring their innovations are protected while promoting a competitive marketplace. This article explores the evolution of trademarks and patents in Grenada, from their historical roots to their current framework, challenges, and future prospects. Fun fact: Grenada was twice a French colony during its colonial history. In a persistent tug-of-war between Great Britain and France, the island changed hands multiple times. Ultimately, Great Britain regained control of Grenada in 1783 under the Treaty of Versailles, solidifying its rule after years of conflict. Early development of IP in Grenada. During Grenada's colonial period under British rule, IP laws were primarily designed to serve British interests. Local entrepreneurs faced significant challenges in protecting their creations due to limited access to IP protections. The legal system was not tailored to support local innovation, leaving Grenadian businesses vulnerable to exploitation by larger foreign entities. Trademarks and patents were largely inaccessible to local inventors. For instance, trademarks were often registered in the United Kingdom rather than locally, creating barriers for small businesses in Grenada. Similarly, patents required adherence to British legal frameworks, which were complex and costly for local inventors. This lack of inclusivity stifled innovation and discouraged investment in new ideas. Post-independence reforms, building a legal framework. After gaining independence in 1974, Grenada embarked on a journey to establish its own legal system. Recognizing the importance of IP for economic development, the government introduced key legislative reforms. In 1984, the Trademarks Act was enacted, allowing businesses to register trademarks locally. This legislation marked a turning point by enabling companies to protect their logos, product names, and branding within Grenada. It provided a foundation for fostering brand loyalty and market differentiation. The Patents Act, passed in 1995, further strengthened Grenada's IP framework by granting inventors exclusive rights to their creations. This law encouraged innovation by providing inventors with the confidence that their ideas would be legally protected. These reforms were instrumental in empowering local entrepreneurs and fostering a culture of creativity. Modernization of trademark laws, the Trademarks Act of 2012. One of the most significant milestones in Grenada's IP history was the enactment of the Trademarks Act of 2012. This legislation replaced outdated laws and introduced several modern provisions. Registration process. The Act streamlined trademark registration by aligning it with international standards such as the NICE classification system. Applications could now specify goods or services under standardized classes. Duration and renewal. Trademarks were granted for an initial period of 10 years, with the option for indefinite renewal every 10 years upon payment of prescribed fees. Priority rights. The Act allowed applicants to claim priority under the Paris Convention for earlier trademark applications filed in other member countries. Collective marks. Provisions were introduced for collective marks used by associations or groups to distinguish their goods or services. Enforcement mechanisms. The Act strengthened enforcement by addressing issues like infringement, counterfeit goods, and cyber piracy. This comprehensive legislation positioned Grenada as a more attractive destination for both local businesses and foreign investors seeking robust IP protections. Patent protections, local and international integration. The Patents Act No. 16 of 2011 modernized patent registration processes in Grenada. This legislation replaced outdated requirements and streamlined Grenada's patent laws to mirror international standards. It allows inventors to file local patent applications or extend rights from UK registrations within 3 years of filing in the UK. Key features include documentation requirements. Applications require detailed descriptions of inventions, claims, abstracts, and relevant drawings. Paris Convention priority. Inventors can claim priority under this international treaty for earlier filings. Patent Cooperation Treaty, PCT. As a participant in the Patent Cooperation Treaty, PCT, Grenada enables streamlined patent filing processes, allowing inventors to seek protection for their innovations across multiple jurisdictions with greater ease. These measures encouraged innovation by providing inventors with clear pathways to protect their creations both locally and internationally. Fun fact: the Corporate Affairs and Intellectual Property Office, CIPO, in Grenada was established in 2009 under the Ministry of Legal Affairs. It is tasked with overseeing all matters related to IP, including trademarks, patents, copyrights, and their enforcement within Grenada. International partnerships and treaties. Grenada's commitment to strengthening its IP framework is evident through its participation in international treaties. World Intellectual Property Organization (WIPO) membership provides access to global resources and expertise in IP management. This UN specialized agency has 193 membership nations. Paris Convention for the Protection of Industrial Property. This treaty enables businesses to protect their trademarks and patents across the 180 member countries. Patent Cooperation Treaty, PCT. This treaty facilitates simplified patent filings for inventors seeking protection in multiple jurisdictions. To date, 158 participating nations have joined the PCT. These partnerships not only enhanced Grenada's legal framework but also boosted investor confidence by ensuring compatibility with global IP systems. Economic impact of trademarks and patents. Trademarks and patents play a critical role in Grenada's economy, particularly in industries like agriculture and tourism. Agriculture. The spice industry benefits significantly from trademark protections that distinguish high-quality Grenadian nutmeg, mace, and other products on international markets. Tourism. Trademarked branding helps promote unique tourism offerings such as ecotourism ventures or cultural experiences. Digital economy. Emerging sectors like software development require updated IP laws to address challenges related to digital content protection. The ability to protect IP has empowered local entrepreneurs to compete globally while attracting foreign investment. Challenges facing IP protection. Despite progress, several challenges persist. Awareness gaps. Many local entrepreneurs remain unaware of the benefits of IP protection or how to navigate registration processes. Limited resources. Small businesses in Grenada often struggle to secure trademark and patent registrations because they lack the necessary financial resources and technical expertise. Furthermore, the cost is often prohibitive for the local population, highlighting the need for greater support and accessibility. Enforcement issues. Counterfeit goods and trademark infringements remain concerns due to limited enforcement capabilities. Limited resources and personnel within enforcement agencies hinder effective monitoring and prosecution of IP violations. This allows counterfeit goods to thrive, undermining legitimate businesses and potentially harming consumers with substandard products. Strengthening customs controls and providing additional training for law enforcement are crucial steps in combating these issues. Digital transformation. The digital age presents new challenges, demanding that existing IP laws evolve to address issues like online piracy. Furthermore, as software development grows, clear legal frameworks for software patenting are needed to foster innovation while preventing overly broad protections. Addressing these challenges requires targeted education campaigns, capacity-building initiatives, and legislative reforms. Future directions. To further strengthen its IP framework, Grenada could consider public awareness campaigns, educating entrepreneurs about the importance of IP through workshops or online resources. Simplified processes, streamlining application procedures using digital platforms like WIPO's Industrial Property Administration System, IPAS. Stronger enforcement mechanisms, collaborating with customs authorities to combat counterfeit goods effectively. Support for startups, providing financial incentives or subsidies for small businesses seeking IP registration. By addressing these areas of improvement, Grenada can ensure its IP framework remains relevant in an evolving global landscape. Conclusion. Grenada's journey with IP reflects its broader efforts toward economic modernization. From colonial-era limitations to post-independence reforms and modern legislation, like the Trademarks Act of 2012 and the Patents Act of 2011, significant progress has been made. However, as new industries emerge, particularly in the digital and technological space, Grenada must continue evolving its IP laws while raising awareness among local entrepreneurs. By fostering a culture that values innovation and creativity, Grenada can position itself as a leader in IP protection within the Caribbean region. Robust IP laws will not only safeguard local businesses but also attract foreign investment, ensuring long-term economic growth for this vibrant tri-island nation. Page 49. Article. Disclaimer: images and references related to this article can only be seen in the print and digital versions of the magazine. Culture, creativity, and commerce. Intellectual property in Pure Grenada, the Isle of Spice. Linda Dolland, Attorney at Law, Notary Public at Sion and Associates, Grenada. Long known as the Isle of Spice, Grenada has, over the years, successfully rebranded itself as Pure Grenada, leveraging tourism as a main driver of its economy, supporting trade, and recently, the orange economy, that is, the creative economy, for increasing and expanding the country's GDP. With global shifts in policies, including tariff impositions, the expansion of the market in the Global South, initiatives such as frequent flights between Grenada and Guyana, and the anticipated Afro-Caribbean Trade and Investment Forum to be held in Grenada in July 2025, opportunities for trade are poised for expansion. For IP practitioners, all of this will immediately mean safeguarding the goods, services, and works that these market prospects will generate. IP protection must be viewed as more than just a legal formality. In an era of digital globalization, it is a strategic tool to protect assets in Grenada and to ensure sustainable development as a key pillar for economic growth. With respect to trademarks, Grenada transitioned from first requiring registration in the UK to its own Paris Convention-based Trademark Act in 2012 for national applications and registrations based on the NICE classification. We've observed that, while traditionally larger international IP owners, retailers, and service providers have continued to register in Grenada, the local market has also begun to recognize the importance of brand protection. Tourism is the cornerstone of Grenada's economy, and IP is key to protecting and marketing the island's offerings. We've had the distinct honor of handling the IP portfolio for the Grenada Tourism Authority, securing protection for the branding as it expands Grenada's tourism product into food tourism, with Taste of Grenada and Grenada Epicurean Safari as protected marks, amongst others. Equally important is protecting Grenadian-made goods, such as nutmeg, cocoa, rum, and handcrafted items, not only from counterfeiting, but also to enhance brand value. We've had the interesting and amusing brief of securing the registration of Fedden rum on behalf of a local entity, which references the name of a historically important individual in the Grenada context, as well as successfully assessing local rum branding against international brand opposition. Conversely, we've had to represent international precious stones retailers in brand infringement matters against local retailers. From these experiences, multiple points are evident. First, that local producers, manufacturers, suppliers, and providers are realizing the importance of protecting their brands, and second, that international brands are keenly interested in Grenada as a location in which they refuse to have their brands diluted. But more is yet to be done in order to secure the agriculturally, culturally, and economically important products in Grenada, for which the country and its producers are becoming renowned, such as our international award-winning chocolates and artisanal waters, medicinal nutmeg products, and one of the oldest functioning water-powered distilleries in the Western Hemisphere. In the absence of a GI regime in Grenada, producers can currently only depend on trademarks to distinguish authentic Grenadian products from counterfeit merchandise. We anticipate that this will become absolutely necessary as Grenada expands its offerings, and cultural events like Spice Mars and the Grenada Chocolate Festival, exceptionally IP-rich experiences, become highly anticipated regional and international events. Trade and cross-border IP considerations. Simultaneously, while we look inward to protect our own goods and services, as IP practitioners, we are keenly aware that Grenada's geographic location positions it as a critical bridge between the OECS, the wider Caribbean and South America, so that more effective use can be made of trade agreements such as the CARICOM-Venezuela Trade and Investment Agreement, which allows selected products which have been agreed to by the parties to enter the Venezuelan market free of duty from all CARICOM countries. Though CARICOM is not required to reciprocate this preferential access, they are at liberty to grant Most Favored Nation, MFN, treatment in respect of all goods imported from that country. Additionally, as trade agreements, including the CARIFORUM EU EPA, increasingly contain IP provisions that require compliance with international standards, it seems inevitable that Grenada will be marching closer to implementing the Madrid Protocol on trademark applications. We therefore anticipate, as a corollary of what we anticipate to be increased registration, from local and international applicants, the requirement for increased infringement and, accordingly, increased enforcement actions. This will invariably require enhanced diligence at our borders and customs, but also closer alliances and relationships with IP practitioners. Strategic outlook. Grenada's gradually increasing IP market is a critical asset for economic resilience and international competitiveness, as Grenada increases its presence on the global stage and is poised to unlock the full potential of its tourism industry, creative sector, and export economy. Undoubtedly, having the right IP partner to guide and advise on IP strategy and implementation will become increasingly critical to ensure that talent, culture, and products are protected and celebrated both domestically and internationally. Page 50. Advertisement. Sion and Associates, Trademark Agents, Grenada. Securing brand identity in Grenada from local markets to global innovations. Trademark registration and portfolio management, oppositions, renewals and enforcement, brand monitoring and infringement protection, trademark strategy. +14734351770. www.sionlaw.com. contact@sionlaw.com. Brigade House, Lucas Street, St. George's, Grenada, West Indies. Anguilla. Page 51. Profile. Name, Keisha Fleming Lake. Law firm, Severi Monsuarez. Position, Managing Partner. Country, Anguilla. Website, www.severimonsuarez.com. Keisha Fleming Lake, LLM, is an experienced attorney who has provided legal services to her clients for over 23 years. Keisha was born and raised in the Caribbean, and from her early adult years, she resided both in the United States and the Caribbean. Keisha maintains a professional and social residence between Anguilla and Florida. Keisha acquired her education in the United Kingdom, the Caribbean, and the United States. This solid educational background provided her with the necessary foundation to build upon and establish a successful legal career in the Caribbean region and the United States. Keisha started her legal career in the United States as an associate for a major U.S. law firm, where she provided legal services to Fortune 500 companies. During this time, she developed a sound understanding of the demands, attention, and quality of service that these institutions require from their legal counsel. Following this, she practiced law in Anguilla, thereby developing her skills and understanding of the legal system in the Caribbean region. To qualify to become a licensed attorney in the Caribbean region, Keisha studied at the Eugene Dupuc Law School in Nassau, the Bahamas. Having the qualifications and an extensive background in practicing law in the Caribbean and the United States, Keisha is skilled in navigating all aspects of IP law. Her understanding of the legal system in the Caribbean has allowed her to develop the expertise necessary to build her practice in the region. She is known among her peers and the IP registries in the Caribbean region for her diverse knowledge and skills. She is a registered attorney in the United States, Michigan, Florida, Missouri, and the Caribbean, Anguilla, Antigua, Barbuda, St. Kitts, and Nevis. Keisha focuses her practice on both IP law and corporate law matters. Keisha has tailored her practice to give each of her files the personalized, individualized attention required to ensure that applications are processed promptly and effectively at IP offices throughout the Caribbean region. This is especially important to her, as attention to detail is needed for this region that continues to be a majority manual jurisdiction. Having been involved in IP law matters where applications were refused due to complicated issues and obstacles, she has successfully resolved the issues, resulting in registrations and processing of applications. She has developed her expertise to manage large and complex IP portfolios in the Caribbean. Over the years, Keisha has developed an understanding of the requirements of the various IP offices throughout the Caribbean region. She remains actively involved in managing trademark portfolios for corporations and individuals. Using her knowledge of the Caribbean region and IP law practice, Keisha has authored and co-authored several articles on trademark law practice in the region. Her memberships in the bar associations and Caribbean IP law associations give her direct access to updates in the laws of the region and developments at the local registries. In addition to being a member of the various Caribbean and United States bar associations, Keisha is a member of the American Bar Association, the Inter-American Association of Intellectual Property, ASAPI, the American Intellectual Property Law Association, AIPLA, the Organization of Eastern Caribbean States Bar Association, the International Trademark Association, INTA, the Intellectual Property Caribbean Association, and the Palm Beach County Bar Association. Page 52. Article. Disclaimer: images and references related to this article can only be seen in the print and digital versions of the magazine. Transforming Trademark Law in the Caribbean, New Legislation Empowers Brand Owners. Written by Keisha Fleming Lake, Managing Partner at Cerveri Monsuarez, Anguilla. This article serves as an update to my ongoing written work about the trademark practice in the Caribbean region and the evolving intellectual property, IP, legislative regime. In 2022, I made some bold predictions about the direction of IP legislation in the Caribbean region. In 2023, I continued to track the progress of the jurisdictions implementing new legislation in the Caribbean region, making further predictions at each stage. This article covers new legislation and confirms that the growth and strengthening of the IP regime in the Caribbean region through new legislation is ongoing. In the Caribbean, the group of over 28 countries is referred to as one jurisdiction. It is misunderstood as a jurisdiction governed by a single legislation with a unified approach covering all countries. In reality, the Caribbean is made up of about 28 independent jurisdictions, each operating under its own legislative framework. This suite of legislation and regulations that provide protection for IP rights are unique and applicable to each jurisdiction separately, creating its own unique IP regime. This makes IP practice in the Caribbean unique, further complicated by the fact that several jurisdictions are manually operating under legislation that is outdated and not in line with current practices. Recently, several jurisdictions have implemented new legislation that introduces a more modernized, strong, and effective IP regime. In some of my previous articles, I discussed several new IP laws. Practitioners in this region are excited about the new IP laws, but we remain mindful that the Caribbean region requires a practice that includes significant attention to detail, patience, and skill to navigate the various IP regimes. Practitioners must stay up to date and build a working partnership with the heads of IP offices and examiners, with whom they often come face to face while advocating on behalf of brand owners. New IP laws in Bermuda. Legislative reform in Bermuda remained pending for several years. Finally, after a much-anticipated wait, the Bermuda Trademarks Act 2023 is expected to come into effect in 2025. Bermuda's trademark legislation, established in 1974, needs to be updated to modernize the IP framework. According to all reports, the new legislation will modernize the IP regime, creating one more in line with the UK IP regime and global standards. Bermuda's trademark registration period is currently 7 years, and the renewal period is 14 years. Under the new legislation, one significant change is the implementation of a 10-year time period for registration. Currently, brand owners must associate similar or identical trademarks owned by a single owner in identical or similar classes. The new legislation removes the associated trademarks system, meaning it will no longer be necessary for brand owners to associate their identical or similar marks. The new legislation will also implement the single register system, removing the split of Part A and Part B trademark registration. This step towards modernizing the laws is welcomed by practitioners, local and international brand owners, and IP administrators. This type of legislative reform of Bermuda's IP laws provides brand owners and creatives with the tools needed to identify and protect their IP and, through the legislation, enforce their IP rights. We expect a revamping of Bermuda's IP legislation related to trademark, copyright, and patent protection. Bahamas IP legislation to be updated. The Bahamas will see significant updates to its existing IP legislation, which dates back to the early 1900s and does not offer protection for services. In February 2025, an announcement was made informing the public about the updates to the IP regime in the Bahamas via the highly anticipated new legislation. This legislation has been sitting on the horizon awaiting implementation in the Bahamas for a long time. The new IP suite of laws includes the Trademarks Act 2024, the Patents Act 2024, and the Copyright Act 2024. The anticipated legislation will bring the IP regime in line with global standards and modernize the IP framework in the Bahamas. For example, registration of trademarks for the protection of services is now possible under the new legislation, and the classification of goods and services will be as per the NICE classification system. Under the former legislation, the registration period was 14 years. Under the new legislation, the registration period will be 10 years with a corresponding 10-year renewal period. Of most significance is the establishment of the Bahamas Intellectual Property Office, which will enforce the new legislation and implement the policies and procedures for the transition. Legislative reform is still needed. With the new legislation in the Bahamas and Bermuda, the Caribbean region continues on the path to creating a strong IP regime. In previous articles, I wrote about the new laws in Trinidad and Tobago, Jamaica, the British Virgin Islands, Antigua and Barbuda, and some other jurisdictions that started the region on this journey some years back. While I am happy to report that my predictions are coming to pass with more new legislation, I am also the first to admit that more is needed. Jurisdictions like Suriname and Guyana still operate under very old IP laws, and we anticipate that there will be more legislative reform to bring islands still lagging behind in line. Conclusion. The trend of IP legislative reform throughout the region will continue to shape the development of a stronger IP system in the Caribbean. This trend will result in more IP protection for local and international IP holders and an increased focus on enforcement actions. In conjunction with the new IP laws, it is my prediction that more jurisdictions will sign onto the Madrid Protocol.
Page 54. Advertisement. Grant Henry and Rooms, Attorneys at Law. Your IP partner in Jamaica. Our team is well versed in intellectual property law, offering services to protect your patents, trademarks, copyright, and more. We provide strategic advice to help safeguard your innovations and intellectual assets. Copyright registration, advice, and dispute management. Trademark registration, maintenance, and dispute management. Designs registration, maintenance, and dispute management. Patents registration, maintenance, and dispute management. Contact Lisa at ghrlegal.com. Telephone, +1 876 676 6926 or +1 754 336 1080. Suite 5, 94C Old Hope Road, Kingston 6, St. Andrew, Jamaica W.I. www.ghrlegal.com.
Page 55. Inside back cover advertisement. Caribbean Trademark Services. Law Office of George C. J. Moores, PA. Over 40 years of one-stop trademark services in the Caribbean. www.caribbeantrademarks.com. Telephone 1-561-833-9000. Fax 1-561-833-9990. Email ip@caribbeantrademarks.com. Address 2855 PGA Boulevard, Palm Beach Gardens of Florida, 33410.
Outside back cover advertisement. Final page. Colb's Estudio Legal. Sebastian Jimenez M. LL. M. Sebastian.Jimenez@colbs.cr. www.sebastian-jimenez.com. Jessica Ward. Jessica Ward@colbs.cr. COLBS Estudio Legal. Avenida Las Americas, Calle 60 Torre Lane, Sabarner, Piso 3, San Jose, Costa Rica, 10108. Anguilla, Antigua and Barbuda, Aruba, Bahamas, Barbados, Belize, British Virgin Islands, Central America, Cayman Islands, and many more. www.colbs.cr. +50 64700 6400. info@cobes.cr.